I need to mention one application. Epilepsy question.
Appellate mentioning.
Any other appellate side mentioning?
আজকে প্রথমে কি অ্যাপেলেট সাইড কি কমার্শিয়াল দেখো দেখো
Non-commercial matter, item number 1.
এটা তো আমাদের তো
নন কমার্শিয়াল ওয়ান
নন কমার্শিয়াল তো
ক্যাব ইঞ্জিন
ক্যাব ইঞ্জিনিয়ারিং
ইয়েস
millet restoration along with section 5 millet. The other side used an affidavit, we have used
is an affidavit in connection with section 5.
section 5
What is the delay? How much delay?
84 days.
81 days. Who is there for the other side?
Mr. Shen was there, millet.
Mr.
Chakko Shen.
Kakushen. First call, pass it over, Mr. Shengupta. First call. Now. কি হলো কৌশিক আবার ডুব কেন আজকে কবে ঠিক আছে চল নাম্বারটি নিয়ে না না কোনটা করে
Number 2.
এই
Item number 2.
ওর ভুল ফাইল দেবে আমাকে দেখিয়ে নিতে অ্যাপেলেন্ট ইজ নট হিয়ার স্যার শুনুন দুপক্ষ না থাকলে পাস ওভার করে দেবেন ফাইল বার করে সময় নষ্ট করবেন না
No, no. Item number 3. Item number 7. Item number 9.
সেকেন্ড কল
Second call, passover matter, item number 1.
So our application millet, the difficulty is that millet, the execution is on the running on the list millet.
No, they are not opposing. Nobody is appearing, so we'll allow your application.
My lord.
In the first call, nobody appeared for the respondent. In the second call, also nobody appears.
Just on his way. 5 minutes.
So we'll wait.
5 minutes, my lord.
We'll rise for a cup of tea. What to say? Not today or what? We can't
Millet,
wait.
not today.
Or pass over then. Let him come.
When he will come?
No, on his way is the vaguest possible statement,
No, no.
madam. He can be on his way from New Delhi. He cannot be on his way from his house. So we don't know. You want to wait or not today? What do you want?
No, millet, I have to do it because the execution they are proceeding with.
Then wait. 81 days delay কেন অপোজ করছে আমি বুঝতে পারছি না পাস ওভার চল
Item number 2.
I am appearing for respondent. Last occasion, my lord, in this matter,
এই ফার্স্ট কলেও ছিল না ইউজুয়াল অর্ডার
matter has been settled. We are filing the terms of settlement.
ও
This is the matter where settlement was
দাঁড়াও
going- this, they have paid the money and
And
the
for the
completion
petition.
certificate they have issued. We don't have any claim against them now.
সেটেল হয়ে গেছে আমি ডিসমিস করি লেখো read order dated April 17, 2025 paragraph. $29 lakhs.
29 lakhs. 36 our claim, but we have settled on 29.
Learned advocate.
I mean,
The original, have you handed over?
No,
The original has to be handed.
they have the original because
No. You are for the
I am for the respondent.
respondent. Learned advocate for the respondent. Now, learned advocates for the parties say that the parties have settled the matter out of court. Stop. The respondent has agreed to and has in fact received rupees 29 lakh in full and final settlement of its claim against the appellant. Stop. Record notes of discussion held between the parties along with completion certificate and a copy of a banker's check.
It has been encashed.
Banker's check for rupees 29 lakh drawn in favor of the respondent is filed in court today. Stop. Let the same be kept with the records. Paragraph. In view of the aforesaid, comma, FMAT such and such is disposed of along with can such and such.
Lordship, one thing that learned trial court will act on the server copy of the, we have to withdraw the suit before the trial court on the act of the server copy. Otherwise, they will say go before again
Paragraph.
applied.
All concerned, including all concerned and learned trial court.
Sorry,
And
my
learned trial court. Well, yes, yes, we could see you. You were there. এই অ্যাপিয়ারেন্সটা যেন থাকে ওর নাম প্রচন্ড দৌড়ে এসছে
No, no, appellant.
and the learned trial court to act on a server copy of this order.
I am grateful, man.
Item number 3.
ছিল আগেরটা ছিল না ইউজুয়াল অর্ডার অভিজিৎ
এইটা খালি যাবে।
হ্যাঁ
Item number 7.
এটা অ্যাপ্লিকেশন করেছে 2022 বোধহয় না এটা তো কোনো অ্যাপ্লিকেশন দেখো তাহলে ফ্যামিলি
কোনটা?
কি কি হয়েছে আইটেম নাম্বার
Item number 7.
7 ছিল কেউ
না, first one.
7, my lord. I appear for the appellant, my lord.
ইয়েস
By section 37 appeal, my lord.
হ্যাভ ইউ সার্ভড
Mr. Shatru Banerjee was appearing.
Aturu Banerjee not here sir what to do shall we say not today
My lord.
not today ইয়েটা ডাকো পাসওয়ার্ডটা ডাকো
Passed over matter. Item number 1.
Mr. Sen has come.
that is why we called the matter
Finally. This is the.
Please tell us 81 days delay you know how our approach is Mr. Sen
But I know your lordship's approach, but kindly have a look at the date of the award. And my lord, how the things have progressed before this restoration. My lord, your lordship has seen the. Well,
Mr. Sen all we have to consider in the restoration whether there was some reasonably sufficient cause whether we are satisfied nobody really wants his matter to be dismissed for default so and there was some delay you know how the state acts
may I say
you
this?
know best how the state acts
But may I say this, my lord?
yes
Let the main appeal
yes
also appear on a particular day.
yes
And your lordship may fix it.
we'll fix it
Let this restoration application along appear with that appeal. My lord, your lordship will restore and hear out the appeal.
দাদা
Mr.
paper
Sen,
book হয়েছে।
we will direct listing
Why telling your lordship?
we will direct listing of the appeal and we assure you if you both sides are here we'll take it up
I am not making this submission because the court is unable to take up. I am only making this submission because if the same thing happens again, then again they will come with a restoration. Kindly have a look at only one thing, one date. What is the date of the award? After how many days they preferred the appeal? At that stage, court exercised the discretion and condoned the delay, substantial delay of more than 195 days. So it was condoned. Matter was kept pending from 2013 onwards till 2025. 25 Also, the court records that repeatedly they did not come. That is why the court had to exercise the discretion to dismiss it for default. I am not making the submission that the court is unable to take up the matter. The matter has been running in the list for the entire 2 months
34, there 34 was dismissed by this court, but I mean High Court.
by the trial court. So they prefer a 37 appeal.
And Millard, we have, in addition with that, Millard, we have already deposited the principal amount before this, the register general. That is lying with him, Millard. The 55 lakhs is lying with him. But the understanding was that, Millard, there is an unconditional delay to that extent. Kindly have a look into the Millard, the stay of the Millard, the order dated 27/7/2013.
But I will only say only 2 dates, my lord.
Millard, Mr. Sen is saying his application got dismissed. It was 580 days. It was condoned by the bench. This execution case.
Whose application got dismissed?
Mr. Sen's application.
589 days.
589 days.
What to do with this appeal? I think my learned friend is confused. I'll give you a only 2 dates thereafter, your lordship.
Why are you keeping us occupied with this, Mr. Sen?
I'm not, but just 1 minute, 2 dates.
Tell us.
But 31st
Judgment.
January 2006 was the date of the award. Then, my lord, they challenged it. 2009, this award was set aside by the learned court below. But after 2009, appeal was preferred in 2013.
By you.
No. I am the award holder.
Award was set aside, you said. In 2009.
I'm sorry, my lord. The 34 was, they filed the 34 was dismissed. 34 was dismissed after 4 years, 2013. 37 appeal was admitted with condonation of delay. From 2013, this was kept pending. 2025, when the division bench records that repeatedly the matter has been called, they have not appeared. Ultimately, it has been dismissed for default.
We completely appreciate this has to be immediately heard out. Yeah.
That I am only saying, on that date, the lordship will keep this application and the appeal, let it be heard together.
Mr. Sen, we are here for a few more days. If it is again dismissed for default, they can rest assured we are not going to restore it.
Mal.
They have to go to Supreme Court for that. No doubt about that.
I have nothing much.
Delay now again. Huh? This is application. This is an application for condonation of delay of
81 days.
1 days in presenting an application for restoration of FMA number 2795 of 2013, which was dismissed for default on
17th December 2024.
December 17, 2024. Paragraph causes shown being sufficient, the delay is condoned. Stop. GA such and such. GA to na. If can is this. Can such and such is disposed of. Unno canter now. This is an application for restoration of FMA number 2795 of 2013, which was dismissed for default on December 2024. Stop. Paragraph. We have heard learned counsel for the parties. Stop. We are satisfied with the explanation furnished for absence of learned advocate for the appellants on the day the matter was dismissed for default. Paragraph. Accordingly, the order dated December 17, 2024 is recalled. Stop. FMA such and such is restored to its original file and number. The canter disposed of. Next. Appeal to now. This appeal was now. The arbitral award in question was passed in 2006.
31st January 2000.
On January 31, 2006, in favor of the respondent herein. Stop. After substantial delay, in 2009, the appellants challenged the award by filing an application under Section 34 of the Arbitration and Conciliation Act, 1996. Stop. That application was dismissed. Stop. Again, after substantial delay, the present appeal was presented against the order of dismissal of the setting aside application. Stop the appeal. The appeal was admitted in 2013 after condoning the delay. Stop. Since then, the appeal is pending. Paragraph.
Also record, Millard, we have deposited the Millard 55 lakhs 96,844, and that is why the unconditional stay was there.
Very well. That is little consolation, seeing the money deposited with the registrar.
Therefore, my lord, may I pray this, my lord? May I furnish a bank guarantee and withdraw the money?
This is the condition given.
Mr. Sengupta, what is the problem? Unconditional bank guarantee from a nationalized bank. What is the problem?
That is now the usual order, my lord,
Yes.
36 cases.
Yes. You also know, we don't know, but you know how much merit you have in your case. We
No,
don't.
that is
We may pass that order. We may pass that order. কি হলো? After condoning,
the counter bank
after
now-
condonation of the delay. Condonation of the delay. Stop.
Millard,
You take instruction and come back if
I'll-
you like. We are just recording this. Appeal is pending.
I am told, my lord, that liberty was already there in the order at.
if your lordship kindly take trouble to see Millard 27th 22nd July's order, Millard. The CAN 570, Millard. Kindly take trouble to see the page 2 onwards. 22nd July 2013's order in CAN number 570.
কোথায় বাবা? CAN number 570.
No. This is Millard. This is the order. একটু দেখিয়ে দাও না।
No, the order admitting the appeal should be in our file.
Yes, it is there, Millard.
Then why are you giving us that? এখান থেকে বার করে দিন না আমাকে। Seriously? কি করে পেলি কি আপনি?
22/7/2013।
Already 71 of
হ্যাঁ, subject to the satisfaction.
Conditional stay.
Subject to the satisfaction.
Yes, it is already there, Mr.
Yes.
Sen. So take steps. We have just restored. We are listing it next week. In the meantime, do whatever paragraph, list the matter on Monday. Monday date diye dao.
And only one request,
This is the
Mr.
appeal,
Sen
huh?
Millard. Since I have been newly engaged in this matter, I have no clue whether the paper book has been filed or not. Direction was given, Millard. If it is not there, Millard, I will pray for it and
Paper book is there.
It's there.
no, Millard, আমাকে একটা copy দাও না একটা। Well, in that event, you will kindly do not take it up on the Monday, Millard.
Mr. Sen, if you have been permitted to withdraw, do that, then where's the urgency? I mean, just before vacation,
But you will keep it
immediately after the
My lord,
vacation.
my
Huh? 10 June.
10 June, very good. Copy দিও না একটা।
এই দুটো GA না can dispose of করে দাও।
My lord.
We take our chance, my lord, if they don't press the appeal, my lord, then I shall
The
press.
first question was to be condoned or not to condone.
First question, to be or not to be?
To be or not to be.
হয়ে গেল?
Intelligence, my lord. Just the previous matter, item number 3.
3.
My lord, I just got
You are for
for the appellant, my lord.
corporation?
No, it's Kolkata Metropolitan
Oh,
Development
KMDA.
Authority. KMDA.
Yes.
My lord, I was just coming
No, it's an appeal of 2008, sir.
2008. My lord, the appeal is ready. It has been substituted on the last occasion.
করো না, তিনের অর্ডারটা করো না, ডিসমিসেলটা করো না।
On the last occasion,
today.
the respondent prayed for some time for.
Not today, not today.
তিন নম্বর ফাইলটা বার করবো না, হ্যাঁ, not today. Item number 9. আমাকে দিন।
আমি বোধহয় একটু কিছু নোট ফোট করছিলাম কিনা দেখুন। নোট আছে কি দেখুন তো। এখানে তো আলাদা একটা ফাইলে থাকবে না? তুই করছিলিস কি নোট? কি করছিস নাকি কিছুই করিনি? হ্যাঁ, 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 correct, correct, correct. ঠিক আছে। Yes. What were the 4 points you had urged? One is that
My-
pre-deposit.
Pre-deposit, my lord, not made, and my lord, then stamping the award has been set aside on ground that the award is inadequately stamped, my lord, which I said, my lord, that is not the law as on date, my lord, it has to be considered in execution.
Yeah.
Thirdly, my lord, it said that the arbitrator and the conciliation proceedings could not be performed by the same council.
Yes.
My lord, that is also, it falls short in view of the rules as well as the provisions of the act itself, my lord, which says that arbitration and conciliation can be performed by the council itself. And my lord, coupled with the judgment laid down in Shilpi Industries, my lord, that arbitration act will not prevail over MSME. And my lord, the last point, my lord, was the supplier issue, which my lord is pending consideration before the larger bench. My lord, I had lordships that it had fallen from your lordships, my lord, the appeal will be pending. But I had, my lord, prayed that since they had not made the pre-deposit, my lord, this application could not have been entertained at all. And therefore, my lord, in the event lordships feel that the appeal should be kept pending, the amount should be secured to the extent of 75%, my lord. But that is all that I had prayed for, my lord. Lord, Mr. Banerjee was going to submit.
No, my lord, till now I have a very ugly face before your lordships, my lord, so far as this matter is concerned. My lord, I'll try, my lord, my level best to satisfy that, my lord.
For how long will you try, Mr. Banerjee? There are other matters also. Just to assess.
20-25 minutes. My
As brief as possible. Yes.
lord, I'll try to.
If you want, you can file a written note.
No, don't do that.
Uh,
Don't do that.
then keep it very short, oral submission.
Very well.
Yes. Indicate the points and file your note.
Very well. I'll do.
Pre-deposit is
The
a
principal
point,
thing, my
yes,
lord,
which is
I
weighing
need to, my lord,
heavily.
address.
Yes.
Yeah. My lord, just kindly have a look at, my lord, the provision of the pre-deposit, which is, my lord, section 19 of the 2006 Act. Kindly, my lord, just have a look at, my lord, the provision.
कौन बोल होटल नाम
MSME.
You were trying to draw a distinction between maintainability and entertainability.
Not only that, my lord, I say, my lord, if there is a fraud, and if, my lord, the arbitral tribunal, my lord, the MSME council here, the facilitation council, my lord, acted, my lord, wholly without jurisdiction, then, my lord, there is no award as such, my lord, that being a nullity. So, my lord, the question of, my lord, putting in a pre-deposit does not arise. And, my lord, this question is also, my lord, pending, my lord, adjudication before, my lord, a 5 judges bench, my lord, of Supreme Court. This is also, my lord, pending adjudication, my lord, that was not known to me. My lord, I did, my lord, a second research, and, my lord, I could, my lord, lay my hand, my lord, on an unreported decision.
What point? Where if fraud is involved, that point?
No, it says, my lord, if the award is a nullity without jurisdiction, then, my lord, whether a writ petition would lie, and, my lord, in case of a writ petition, whether, my lord, the person, the petitioner would be required to, my lord, put in any pre-deposit or not. My lord, honorable bench led by, my lord, the Honorable Chief Justice Sanjeev Khanna, my lord, was of the view that, my lord, in such a case, my lord, even a writ would lie without requiring, my lord, the petitioner to put in, my lord, a pre-deposit in MSME arbitration. And, my lord, the matter was referred, my lord, to the larger bench. And, my lord, there are, my lord, two decisions, my lord, to that effect. Justice Khanna, my lord, relied on a previous decision, which, my lord, we are carrying, my lord, will, my lord, just rely on that. So, my lord, I say on two counts, my lord, the arbitral tribunal, my lord, the facilitation council, my lord, did not have, my lord, jurisdiction. And, my lord, this lack of jurisdiction was, my lord, incurable, inherent. My lord, firstly, because, my lord, he was not a supplier as defined, my lord, under the Act. My lord, unless, my lord, my learned friend's client, my lord,
Why not? Because not registered.
yes.
That is why.
Yes.
As on the date of the supply.
Yes. As on the date of the contract, as on the date of the supply, even as on the date of raising of the bills. So that is, my lord, an admitted position of fact that, my lord, the registration came later. My lord, my learned friend has, my lord, tried to make out a case that, my lord, because of his, my lord, previous registration with, my lord, another, my lord, entity under, my lord, another act.
একটা ঊর্জার জাজমেন্ট বলুন আমরা যদি সেটা সেন্ড করে
আচ্ছা ওইটাই দেখ আমি ওইটাই না সফট কপি আছে
আমরা কি শুনছি এখানে
সাইটেশন I remember when it's
correct, correct. I'm on something else. আমরা যদি না ঠিক আছে ওরা কি বলবে জানি না
আমি
but assuming section 19 by
Fresh in your mind.
the orderটা is back only on that count. এবার আমরা অর্ডারটা সেটা সেট করে দিলাম তাতে কি হচ্ছে ও ও ও আচ্ছা, আচ্ছা। হুম, 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 হুম। Ultimately কি এখন একটা কথা বলেছি ঠিক আছে Like, you have to follow the law as it stands now. Apply that law আর কিন্তু ক্লেমটাই তুলে যাবে পড়ে গেলে যাবে কি করা যাবে এটা আমার মনে হয় একটু নোট নিয়ে নিই সেইটা Yes, Mr. Banerjee.
I cannot resist my temptation just to share one thing with your lordships. Possibly this judgment was yet to come then. I had an occasion to face an interview. I was asked this question whether an award passed by your facilitation council can be challenged in a writ petition. That somehow struck my mind last night. I started hunting for it and I came across this judgment.
Such difficult questions are asked.
This question was asked. And my answer to the question now tallies with my lord's view. So, on 3 scores, principally on 2 scores, there is also a third angle to it, subject to my limitation of understanding. I say that the arbitration itself was before a quorum non judice. Firstly, because my learned friend was not a supplier. If I go by the definition of supplier under that, the act uses 2 expressions. One is enterprise, one is supplier. Separately defined. Every supplier is an enterprise. But every enterprise is not a supplier. In order to become a supplier, an enterprise has to get itself registered under Section 8. My learned friend wanted to draw a line of distinction between someone who is registered as a supplier under a different act at a previous point of time. That is what is pending adjudication before the Honorable Larger Bench. Secondly, I say that this those persons who conducted the conciliation, they themselves could not have acted as arbitrators. My learned friend said that this issue is no more res integra. There is difference of opinion before the Honorable Apex Court with regard to this also. Thirdly, so far as this pre-deposit is concerned, if I say that there was no arbitration proceeding at all, and if there was a fraud, then this was wholly without jurisdiction. This was a nullity. Question.
Fraud will not make it without jurisdiction, but the other point, yes. If it was a quorum non juris, because he was not a supplier.
Yes.
Within the meaning, therefore, inherent lack.
Yes. So then there is no award. And this Honorable Supreme Court is nowadays of the view that even a writ petition would lie then without requiring the petitioner to put in a deposit. So if that be so, my lord, may I ask this question to myself, then why, my lord, I should be, my lord, saddled with the responsibility of, my lord, putting in 75%, despite she not being, my lord, I mean to say, my lord, my learned friend's client not being a supplier. So, my lord, this is one point. So, my lord wanted, my lord, an answer, my lord, on this. My lord, there is a judgment, my lord, Jharkhand Urja Vikash, which was relied on, my lord, in the unreported decision. Unreported? Correct copy, then, okay. My lord, paragraphs 14 to 19 are, my lord, the relevant paragraphs. It says, my lord, there may be occasions where, my lord, even a writ petition challenging the award would be maintainable.
This was a writ petition which went up.
Yes.
This was a writ petition.
Subject to correction, my lord, I'll again check.
Yes, because 34 was not filed. That is recorded.
Yes, yes. And my lord, 14 to 9 deals with, my lord, the maintainability of a writ petition under Article 226 when, my lord, the award is a nullity and is passed without jurisdiction. That's what, my lord, it discusses.
Yes.
My lord, there are decisions, my lord, which are staring at my face, which are contrary to this. My lord, I have a duty, my lord, to.
Those are earlier.
No, later.
Not considering this.
That's why, my lord, Justice Khanna, my lord, sent it before the, my lord, the larger bench.
Oh.
Kindly, my lord, have a look at this.
Again, same thing. If this is the this will- Yes.
Thank you.
Should nullity involved?
No, my lord, in the previous judgment, it was not.
No.
But, my lord, it says, my lord, section 9 is mandatory.
19.
19, my lord, pre-deposit is mandatory.
Yes, which presupposes a valid award.
Correct. But, my lord, there is a departure then, my lord, in the previous judgment, which says that, my lord, in case it is a nullity, that's not, my lord, mandatory. And writ petition
Can be reconciled. Can be reconciled.
can be reconciled. Now, my lord, all are taken into consideration in the unreported decision. And, my lord, questions are framed. My lord, for the larger bench, my lord, to decide.
It's true.
Kindly, my lord, turn to paragraph 19 once in the last but one page. Page 23. Yeah,
हाँ, हाँ, हाँ. What is happening to you?
These are the questions, my lord, paragraph 19. Kindly see, my lord, the third question. So this is also, my lord, res integra tilde. Here, my lord, the same conciliators, my lord, acted as the arbitrators. And, my lord, the way conciliation took place is again, my lord, in breach of, my lord, the Arbitration and Conciliation Act. At every stage, my lord, there is a breach of the statute.
Is there, as of date, is there a judgment of the Supreme Court saying that the council, facilitation council, if the conciliation or now the mediation fails, cannot itself conduct arbitration?
There is a judgment to the contrary which supports my learned friend.
Right.
So,
So, as of date, that is the law.
Yes.
Notwithstanding the reference. Again, Supreme Court is there saying you should not keep matters pending just because there is a reference.
Right.
What the law is today, apply that. You have given us that? No.
They told as such.
No, my lord, I'm
Council, that judgment you have not given us.
I'm not,
Is it
but
Gujarat? My lord, I-
Gujarat, my lord, Gujarat
You-
state civil.
you-
My lord,
you-
arbitration will prevail over
You
conciliation.
annex that with your
Written note, lordship.
written note.
Lord, one more thing, lordship. Just one thing, lord. The unreported judgment and the Jharkhand Urja.
Mr. Banerjee, these copies of the judgments we are returning, please annex with the written note. These are-
My lord, may the note be a little more elaborate than my lord.
Yes, because we are restricting your oral submission. Make it elaborate.
Lord, I'll
We
see
have
that
this vacation ahead of us. It will keep
Lord,
us
one
occupied.
thing, my lord, just one small thing, my lord. This Jharkhand, my lord, judgment, Jharkhand Urja, it was not considered by Gujarat and others, my lord, which is why the reference has been made. Primarily, my lord, because those cases were arising out of a section 34. Whereas this, my lord, Jharkhand Urja has gone straight to writ petition, claiming maintainability of writ petition on grounds of lack of jurisdiction. My lord, factually, my lord, this judgment makes sense. Because, my lord, their conciliation proceedings were not held in order at all. No 34 was filed because they straightway challenged the jurisdiction. Here, my lord, my case is that, my lord, one judgment I want to show, lordship, which I've come across, my lord. The question of jurisdiction, my lord, in section 34 could not have been entertained unless the section 19 was made when the supplier, sorry, my lord, the buyer has taken recourse to section 34. If he had not taken so, my lord, the question of section 19 would not apply. Lordships would apply principles of jurisdiction and maintainability in terms of a writ petition. My lord, where, my lord, Whirlpool Corporation is also relied upon, saying when there is lack of jurisdiction, writ petition is certainly maintainable.
Okay, followed. What is that judgment?
My lord, where is this here? Motion of judgment? My lord, this is, my lord, a single coordinate bench judgment, my lord, of an honorable court, my lord. Section 34, they applied.
Where, my lord, I suffered a defeat. My lord, the judgment my learned friend is relying upon, my lord, is the judgment where, my lord, I suffered a defeat, my lord, before my lord Justice Moshume Bhattacharya.
Suffer in what?
Filed a section 36(2). My lord, filed a section 36(2), and my lord, similar questions were there, my lord, whether a stay could have been given in absence of a deposit. And it has been held, my lord, very interesting, my lord. This one paragraph, my lord, I'll read out.
There, my lord, the issues are completely different there.
Lord, issues are not different to the extent, my lord, the issue is the same. Whether a 34 can be maintained without making a pre-deposit. And my lord, my lord, kindly comes to paragraph 16, my lord. The type.
ইন্ডিকেট করে দিন ওটা যদি রিসার্চ করে পাবেন ইন্ডিকেট করে দিন যাতে আমরা পরে আবার টুল না হবে my lord recalls
there is a judgment of Justice Chandruchud, of the Honorable Supreme Court, which has said that in order to avoid pre-deposit, you cannot take the recourse to constitutional remedies.
Oh, yes. Yes. The three judges bench.
Yes.
Yes.
Has that been considered here?
No, my lord.
So
which would also support the view that her view
pre-deposit is mandatory.
Find that out.
I had
Intention, my lord, of the legislature is very clear in section 19, my lord. And my lord, section 16, my lord, I will read this out, my lord, because of what
Then
Justice
that is the
Bhattacharya has
language. The
recorded.
court says you can go for a writ if you say that this is absolutely
My lord,
without
the
jurisdiction.
issues are
Don't need to say.
different.
that
for-
may have some logic, Mr. Banerjee, because section 34 court would not be as free as a 226 court.
Absolutely.
226 court is not bound by the
Absolutely.
provisions of section 19
Yes.
pre-deposit, because it is only when you prefer an appeal or an application for setting aside an arbitral award.
Will it-
226
Because of the forum chosen by me, that period I am saddled with the
Def-
responsibility.
definitely it has
Parameters
a
are
bearing.
also
Facts remain
different.
the same, the law points remain the same.
You
But only
see,
because of the forum chosen by me.
yes, of course. Because the forum chosen by you is High Court under 226. You do that most often than not, even in electricity cases. When you challenge a final order of assessment, instead of going before the appellate authority under 127.
Will go for a writ petition here and now.
If you can prove that the order is nullity, definitely why not? Because that is why
Withdraw your 34.
that is the principle on
But
which
now that
My
we are
lord, then
getting
I shall
back-
institute my.
you do that in DRT orders also.
We can't stop you from withdrawing your 34.
And my lord, in any event, the fraud that they are alleging, the question of supply, even Shilpi Industries and Gujarat do not apply to me, my lord. It can be
When
distinguished.
you file your note, when will you file? When will you
Well,
file?
My lord, indicating sometime minute after vacation.
No. If you file before vacation, then we can consider
I
it.
will file it before vacation, lordship.
Can you do it? Do it on the last day if you want.
Can you keep it on the last day, minute? I will.
Friday, file it on Friday. Hearing is concluded. Stop. List the matter once again on last din ta দিয়ে দাও under the heading to be mentioned. তুমি কোথায় ছিলে একদিন ভাই? তোমার মুখটা দেখতে পাইনি? অন্যান্য কোর্টে? Under the heading to be mentioned, only to enable learned advocates for the parties to file written notes of argument. Try to find out that Justice Chandruchu's
Yes, my
judgment.
lord.
Which one.
Yes, my lord, I shall do that.
Don't make us work.
No, my lord. My lord, should I annex the judgments
find
all
it-
over again in the some of the copies?
Take these back
Very
from our file.
Grateful,
Hey.
my lords.
Judgment copy গুলো সব ওনাকে ফেরত দিয়ে দাও। It's a pleasure to hear both of you.
My lord can keep the note, my lord. This is for your lordships. This is for the short pointers of the dates and the page numbers. Grateful, my lord.
Only Milord, I cannot put it Milord in my written notes in case my lords are not with me. Milord, kindly Milord restrict me Milord to Milord the awarded principal amount with installment.
Without prejudice, why can't you put it in your note?
Grateful, my lords.
Now, hearing is concluded on the preliminary point only.
My lord, I have argued the entire matter, my lord. Lordship can consider the entire matter. My lord, if lordship desires, it can remand the. হ্যাঁ
Proceed on the basis that the entire
Yes,
matter has
my
been heard. Prepare your note in that manner.
Grateful.
In case Milord it's necessary, kindly Milord tolerate me for 10 minutes Milord on the returnable day. If at all Milord that's required. Grateful to you.
এবার কি হবে? কমার্শিয়াল ডিগ্রি চেঞ্জ করে দেবো ঠাকুরের কথা
দেখুন
কমার্শিয়াল ডিভিশন আইটেম নাম্বার 1
Lordship, item number 1, I'm praying for not today, Lordship.
after the respondent.
You are for the respondent. On the prayer made on behalf of the appellant, let this matter stand adjourned for the day.
Item number 2.
Item number 2, I am the petitioner.
You are for the appellant.
Then, madam.
It, Pass it over. Your other side is not here. This is the first call.
Item number 6.
Appellant. This arises from a decree.
Is there a condonation application?
No, no, no. Let's stay, my lord, an additional evidence. Well, I'll just try and explain. My learned friend, my lord, is appearing for the plaintiff. I'm for the defendant. My lord, a suit was filed, my lord, asking my lord for payment of my lord 24 bills in respect of, according to them, some construction work which was done in my factory, my lord, in respect of a contract of 2009.
Yes.
There was one contract of 2009, and the same plaintiff, my lord, also supplied me, my lord, labor under, my lord, 3 different contracts. I, my lord, cancelled the labor contracts in 2015. There's no dispute that, my lord, all payments in respect of labor, my lord, was paid, my lord, by me. He raised this issue, my lord, that 24 bills. Initially, my lord, he came with 24 bills. Then, my lord, we pointed out 1 bill was paid. And, my lord, he admitted that. And, my lord, he claimed for 23 bills. All these 23 bills, my lord, are undated.
Oh, this is an appeal from decree.
Appeal from decree. My lord, on the face of it, my lord, I'll show, my lord, there was an issue with regard to limitation, which, my lord, is not considered at all. The learned judge says, my lord, that because I had decided limitation earlier, I'm going by that without, my lord, really looking at the fact that, my lord, limitation was challenged in revision. And, my lord, said that all points have to be decided again, including limitation. And, my lord, he's also, my lord, and these bills, my lord, very important in the criminal proceedings. Bills were, my lord, found, my lord, to be not, my lord, genuine. Now, my lord, in this proceedings, he really puts the, my lord, onus on me to go and, my lord, prove his bills. Because our case was, my lord, that the entire work was completed in 2010. There was no question of you raising these 23 bills. These 23 bills were really disputed. And it, my lord, substantial amount, my lord, of the 23 bills, my lord, is 7 crore 78. And, my lord, that, my lord, gets decreed without, my lord, really looking at, my lord, either deciding limitation or, my lord, without, my lord, deciding. My lord, I wanted to just show, my lord, 2 or 3, my lord, documents. And, my lord, this Order 41, Rule 27 is, my lord, on the ground in the cross-examination. We were asked, my lord, whether, my lord, we can produce, my lord, this consent to operate, which was given, my lord, for the factory itself. And we had said we can't produce it now, but we can produce it if required. So the learned judge, my lord, has taken it as if I failed to produce, and, my lord, now I've given those documents as well. Factory license, obviously, my lord, government authority, consent to operate, obviously government authorities. And, my lord, these bills, my lord, if just, my lord, looks at, my lord, these bills, my lord, at page, my lord, 78, 79, my lord, it starts. No, 79 to paid. My lord, page 80. All, my lord, undated bills. 80 to 101. Interestingly, my lord, 79 is the bill, my lord, which has been paid by us, admitted now, my lord, by him also.
Dated bill.
And this was paid, my lord, on 30th September 2011.
এগুলো দিন না আমাকে।
এটা দে না ওই মাটন ফ্ল্যাগ 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 কাটা আছে তো
79, my lord, is, my lord, will see on the right hand side, my lord, the date 21st September 2011. This is, my lord, paid 98 lakhs 14,000.
You admit this bill only.
This bill, and, my lord, paid, and now they also admit it. Initially, my lord, they said 8 bills, now, my lord, and now, my lord, can you see the disputed bills from page 80? (82) 101, all undated and without any reference numbers. And all other bills, my lord, even the labor bills, my lord, which we have paid because he was also supplying labor to us. My lord, that's from 102 to 152. That is also, my lord, dated and we have paid. There's no dispute with regard to that. And surprisingly, my lord, the learned my lord, judge, with the great respect to him, the limitation is an issue. The genuineness of the bill is an issue. Even if I my lord, leave aside my lord, genuineness for the time being, limitation on the face of it, it my lord, kindly comes my lord, to just my lord, one order, my lord, the High Court order my lord, in revision.
Justice Ghosh.
The,
Justice Shubhra Ghosh.
in the civil revision.
So civil revision.
My lord, this is Ajay Mukherjee, my lord. Page 311 at T11, my lord, looks at 311. Being agreed by the order dated 56 dated 19 July 2021, order number 59 dated 16 November, passed by the learned judge, commercial judge Sanson, money suit number Sanson's present application has been preferred. Now, this was, my lord, my dismissal of, my lord, my application order 7 rule 11. Then, my lord, kindly come to 320. Sorry, 319. As regards the claim, 319 page para 15, as regards the claim of the petitioner, suit is hopelessly barred under laws of limitation. Suit has not been filed within 3 years from the cause of action. As such, plaintiff is liable rejected under order 7 rule 11D of the code. It appears that the allegation, counter allegation made by the parties, while plaintiff has contended that cause of action arose on and from 1st February 2015, that is from the date of cancellation of contract without paying dues, and further on 9th April, when defendant company denied the claim of the plaintiff, lastly on 11th May, also and some other dates, that from the Sansan. Then, my lord, kindly come to 16. In the present context, para 16, my lord, page 320. In the present context, question of limitation is not a pure question of law, mixed question of law and fact. In fact, Rule 11D of Order 7 of the court clearly stipulates where the suit appears from the statement plaintiff barred by any law. Here, the word suit appears from the statement in the plaint are important. Present context, plaint at least do not disclose suit is barred by limitation. Then, my lord, at 321.
Yes.
P21, my lord, kindly look at paragraph 20. I am informed that the trial court has already framed issue as to whether suit is barred by limitation, not whether plaintiff has any cause of action to file the suit. In the event of framing said issue, trial court shall decide these issues at the time of final adjudication suit on the basis of oral and documentary evidence and without being influenced by any observation made by this court, since I have not gone to the merits of the case. Now, my lord, kindly just look at page 41, where, my lord, the impugned order is there. Page 29, it starts. Sorry, page 37. Sorry. 29, my lord, is the impugned order. And, my lord, the issues are noticed at page 33. There's framing, reframing, and again reframing. Doesn't matter, but, my lord, kindly look at page 33, issue 3. Is the suit barred by limitation, any other statutory provision? And then, my lord, looks at page, my lord, 37. Page 37. In the application, paragraph beginning on the, in the application for rejection of claim in I number 1 of 22 dated 16/9/2020, defendant raised the same issue of maintaining the suit on the ground of limitation. This court, video ordered it in 19 July 21, rejected the application filed by the defendant, held that the suit had been filed within 3 years from the date of cancellation of the contract. The court also held that the present suit is not simplicity a money suit, but a suit for non-payment of RA bills, and therefore, Section 18 of the Limitation Act to be read conjointly with Article 113 of the Limitation Act, ordered it in 19 July 2021, has not been set aside by the Honorable Court. Accordingly, this court holds that the suit having been filed within 3 years from the date of cancellation of the contract is well within time and not barred by limitation. Issue number 1, 2, and 3 dissent favor. I'm sorry, my lord, this is not a finding with regard to, my lord, he has to go into it. And, my lord, the same finding, my lord, in Order 7, Rule 11, my lord, that's what he said. And the court specifically said, very well, you are not dismissing at the first stage, but you have to hear it on the question of limitation. And, my lord, page 41, My lord, where, my lord, the
We'll hear him. If necessary, we'll hear you in reply.
very well, my lord.
Mr. Mukherjee, two things as of now, without hearing Mr. Banerjee further. One is prima facie, it appears strange that the first RA bill has a reference number, is dated, and the other bills have no reference number, no dates. That's one. Second is Justice Mukherjee, while disallowing the application for rejection of plaint, clearly directed the learned trial court to decide the issue of limitation and other issues, because it's a question of mixed question of fact and law, without being influenced by any observation in the order of the learned judge. Now, the learned trial judge has not applied his mind independently at all. Because Justice Mukherjee did not interfere here with his order, therefore it is held. This is prima facie not acceptable to us. Yes.
Now, my lord, so far as my lord, the first question falling from your lordship is concerned.
Look, we have to hear out the appeal, no doubt about that.
Today,
Question
Mr.
is of
Lordship
stay.
asking about the question of stay and order 41 rule 27. It is settled that it will be heard along with the appeal.
We are not on Rule 27
Stay
appeal.
is concerned,
Yes, yes.
they have to put in the money. This is a money digging. There's no other way. And I can answer your lordship on that point. It's 12 crores, 22 lakhs is due with the interest. Order 41 rule 5.
No. We are active.
Yes, Mr. Mukherjee, you're right. I was under the wrong impression. Mr. Banerjee, I thought we had a discretion. We don't have a discretion.
No, my
You
lord,
have
so-
to furnish security.
Yes, but the amount of security and the quantum of security is with my lord. My
What
lord,
is the decretal amount? Decretal amount.
my lord, not the decretal amount, my lord. That's my lord up to my lord. Whether my lord what is. Because, my
Yes,
lord, I want, my lord,
for the due performance of such decree.
Yes. No, my lord, I'm showing on the face of it, my lord, the decree is wrong.
Even then we don't have a discretion.
My lord,
We are not asking for cash security to the satisfaction of the registrar. Property, whatever the registrar finds acceptable.
my lord,
We'll
my
grant
humble submission-
unconditional, we'll grant unconditional stay for a certain period within which you interact with the registrar and furnish security. And then we hear out the appeal.
That should be a solvent security, my lord. Otherwise, my lord,
Satisfaction of the registrar. Registrar won't be satisfied otherwise.
If your lordship says about the nature of security, that will be easier.
No, we will not bind the. We do it often.
We have faced this type
You-
of problem, that the
No, you
security
can
is not
object to
solvent
it.
and it is,
It will be in your presence.
Lord, one request, my lord, if my lord,
Yes.
what fallen from my lord, my lord, my lord, definitely I'm taking, my lord. If my lord puts in, my lord, because on the face of it, my lord, this decree, my lord, is not sustainable. And I'm not shown, my lord. I'm not.
Then-
So, my lord,
then-
I'm only requesting.
Mr. Banerjee, then don't press for stay. We'll hear out the
Very
appeal.
well, my lord, kindly do that. Best.
We'll hear out the
Yes,
appeal.
yes, my lord, kindly
next-
immediately
next
after
week,
vacation, my lord.
After vacation,
Yes,
immediately.
Yes, absolutely.
then kindly record that they are not pressing for
No, no,
this
kindly,
case,
my
so
lord.
that I am free to execute. I'm free to execute. Otherwise, they will
So,
show
my lord,
pendency
on
of
the,
stay.
I've shown, my lord, a
And
prima
therefore,
facie
the
case.
time in the execute
My lord, I
is
would have
to say.
argued it today, but just before the vacation, my lord, I also can't, my lord, burden the court to say, my lord, that I.
When are you back from?
No, my lord, I'm 9 June, my lord.
From wherever.
No, my lord, I'm back on the 8th.
The paper book that we
If all papers are annexed, we'll
that we need to check, whether all
Check
the
it.
papers are annexed. And the lower court records are to be brought in, this is from the commercial court, Asansol.
that shouldn't take much time.
No, that doesn't. But
We'll place it 1 week after vacation.
the paper books are to be prepared by them. Because we do not know,
Informal
or,
paper
if they do
books.
not want to, let them use.
No,
certified
they'll
copy
prepare.
of the lower court.
They'll prepare informal paper books.
Yes, we'll prepare.
This appeal is directed against a judgment and decree dated December 24, 2024, passed by the learned judge, commercial court at Asansol in money suit case number 06/2020. Now, 2020 renumbered as money suit bracketed commercial bracket closed colon 12 of 2024 key. কি দিচ্ছে whereby the respondent's suit was decreed for a sum of rupees 7,78,93,632. Paragraph appearing for the appellant, Mr. Banerjee, learned senior advocate, submits that the judgment and decree is ex facie unsustainable in law. Stop. He urges a couple of points which we do not deem necessary to record at this stage. Paragraph, Mr. Mukherjee, learned senior advocate, representing the respondent oblique plaintiff, says that there is absolutely no infirmity in the decree. Stop. However, if stay of operation of the decree is pressed for, security has to be furnished in terms of Order 41, Rule 5, bracketed 3 of CPC. Paragraph. Mr. Banerjee, on instruction, says that the appeal may be heard out instead of having multiple hearings. Stop. Paragraph. Let requisite number of informal paper books be prepared by the appellant within a week after the
It requires a comparison with the lower court records.
No, whatever they will give it, my lord.
Let the lower court, let the trial court records be called for.
Yeah.
Trial court, yes. You'll
Sir, I
put
made
us
a
in
mistake.
difficulty.
I made a mistake. TCR, not LCR.
TCR.
Lower court nahi.
Trial court records be called for. Stop. Let requisite number of informal paper books within.
My lord, 2 weeks. After a week.
Within
2 weeks.
Within 2 weeks after vacation.
No, my lord, a week after vacation.
Within 1 week after the summer vacation. ব্র্যাকেটে তারিখটা দিয়ে দাও 16, হ্যাঁ, June 16. Stop. All formalities are dispensed with. Stop. Since the respondent is represented, comma, notice of appeal is deemed to be waived. Stop. Paragraph lists this matter on June 17.
Yes.
The application for additional evidence has to be heard along.
Paragraph, the application for additional evidence being can 2.
Can one, can two, can one or two?
Can 2.
And my lord, there's a supplementary affidavit, my lord, where some documents were not there, my lord. That also, my lord, I'm filing, but I'll put it in the paper book.
In connection with
In can 1.
being can 2 of such and such, be listed with the appeal and be heard together with the appeal. Paragraph. Can 1 will dispose of then.
My lord, the supplementary affidavit put on record, we'll put everything, my lord, in the paper.
Supplementary affidavit filed in connection with the stay application being can 1 of 2025 is taken on record. Stop. Can 1 stands disposed of. Stop. However, copy of can 1 and the supplementary affidavit be included in the paper book for the purpose of reference. 17 June বলে
17.
দিয়েছি।
ওই সাপ্লিমেন্ট যে ডকুমেন্ট গুলো নমিনেশন ওগুলো মিসিং ছিল
Sure.
সেটা
নাও বাবা।
হ্যাঁ ডকুমেন্ট
একদম লিস্টিংটা একদম লাস্টে দেবে।
গ্রেটফুল
না ফার্স্ট ফাইলটা দিতে হবে মনে হয়।
হুম।
17 তারিখ হিয়ারিং আছে।
Item number 7.
Lord, I am for the appellant. Lord, in this matter, this appeal arising out of the refusal of the interim order passed by the Learned Commercial Court.
সুশান্ত কুমার মুখার্জি?
Yes.
Yes.
Lord, this is marking as a first miscellaneous appeal. Lord, until and unless your lordship directed me to serve copy of the other side, Lord,
Serve refusal to pass interim order.
interim order.
You are the plaintiff.
I am for the plaintiff.
The appellants have come up against an order of the Learned Trial Court refusing to pass an interim order in favor of the appellants oblique plaintiffs. Paragraph. Let service of the appeal papers be effected on the respondents and affidavit of service be filed in court on the next date. When will you come back?
After the opening.
After the opening. Very good. Paragraph as suggested by learned advocate for the appellants, comma, list this matter on June 10.
June 10, huh?
Wiki.
775. Item number 8.
Worrying. Very worrying. Yes, who's the appellant?
I am for the appellant. My lord, very humble prayer, my lord, I have before your lordships here. We had, my lord, we are the defendants, my lord, in a money claim. Now, there was an order of ad interim injunction made. It's in connection with promotion and development of real estate, a part of the services of which had been provided by the plaintiff. Allegedly, the plaintiff has not been recompensed, my lord, for the purpose of his services, in lieu of his services. Now, my lord, after the ad interim order was made, we entered appearance. And thereafter, my lord, we took out an application under Section 8, saying that there was a clause which resembles an arbitration clause, and therefore the matter should be relegated to arbitration. The Learned Trial Court agreed with us, and my lord, relegated the suit to arbitration. From there, my lord, the plaintiff filed a revisional application, And there, my lord, this honorable court was pleased to set aside that particular order, send it back again. Matter traveled to the Supreme Court without any result. And therefore, the suit went and got reopened. When the suit reopened, the date was fixed, my lord, for the purpose of filing written objection, my lord, to the application for temporary injunction. There was a temporary injunction granted. On that date, my lord, we had filed two applications. One,
Injunction restraining him from
restraining
you
us,
from?
restraining me from transferring or dealing with certain flats which are within my allocation
In that property.
in that property. Now, he's a supplier. He has nothing to do with any right, title, or interest in connection with any of the allocations. Be that as it may, that ad interim order was granted. Now, my lord, on that day we appeared and we pointed out by filing two applications on demurrer. Firstly, that this is a commercial suit, but the prerequisites of being a commercial suit have not been properly for dispensation of leave 12A had not been properly mentioned in the plaint. It was just lip service and a single line, which was perhaps which under the law holding the field now would require a little more of improvement in the plaint for it to really pass muster before the honorable trial court. And we said that therefore that leave ought to be recalled. It was passed ex parte as it should have, but then that leave ought to be recalled. That was our first application. We also filed an application of the nature of demurrer in connection with the injunction application, saying that this is a money claim simpliciter, and under the circumstances mentioned here, no injunction would lie, and no case for attachment before judgment had been made out, and therefore the injunction application should be dismissed. These are the two applications we filed, Lord, after the suit got revived. The learned trial judge, Lord, was in a bit of a quandary. The learned trial judge said, if you have not filed your written objection to the temporary injunction application, I'm not going to allow you leave to file it. So I'm going to hear out the temporary injunction application on the papers. Yet the learned judge, trial judge said that we will permit you to file a written notes of argument in connection with the temporary injunction application for all its worth, where you can take all your points and place them before me for consideration. After that, my lord, the injunction hearing concluded. The plaintiff was heard on facts. I was not heard on my facts because my written objection was not there. And I filed my written notes on submission. The plaintiffs, I am told, have similarly filed their written notes on submission. Subsequently, by the order impugned, the learned judge says, but you have not filed any written objection to the temporary injunction application. Therefore, the facts are admitted. And on such, why should I go into your written notes at all? Because I cannot consider your written notes on merits because you have not filed any objection to the temporary injunction application, and then passes a blanket order of injunction. Earlier, it was a few number of flats. Now tells me, do not deal with your allocation at all. There's no schedule in the injunction, but then schedule and all that can be worked out from the plaint maybe. The thing is, an injunction scenario and a 38 Rule 5 scenario are different. 38 Rule 5, the law is stricter. You'll have to make out a case of 38 Rule 5 for an attachment before judgment. There are procedures where you have to put the defendant on notice as to why you should not.
You are the appellant.
I'm the appellant defendant. All that I'm submitting here today, I for Mr. Chaudhary's consideration.
You can't go for mediation.
That is what I said. Here is this is a fit case for mediation. I'll tell you, Lordship, why. That is why 12-way dispensation, Lord, I was really going, because I have a few claims against him also, which are money claims in nature. He has a few claims. I have a counterclaim which is higher than his. And this is not an advocate's manufactured counterclaim that it has to be higher than the main claim in order to look taller. Perhaps the party.
Try it out.
I have no objection.
Try it out.
Ultimately, I'm a businessman. I'm a civil contractor. I'm interested.
But how does he get? The only thing is,
in my money. I will, and there's no dispute on my bills. We'll go for mediation and we'll hope that it succeeds.
the only thing is, by the order impugned, I am restrained from, my lord, dealing with any flat within my allocation. Now, he has a particular claim against which I have a counterclaim. Even assuming his claim to be some sort of a, giving it prima facie badge of merit, which can't be given, that then also the sweeping kind nature of injunction here.
Something which will be make more commercial sense.
Yes.
My learned friend can, my lord, give a bank guarantee for my principal claim. And, my lord, free the flats and, my lord,
We
sell
can
them.
vacate the case. We can
Vacate
vacate the
the
injunction.
My lord, that then
What
will-
is your principal claim?
I'll just tell you, lordship, from the plain.
We'll vacate the injunction.
Yes. So then
We
what
have a-
happens is, my lord, that he, my lord,
And then you go to the mediator.
That kind of becomes then, my lord, a security under Order
Yes.
38 Rule 5.
and that will
In a
be
way,
subject
that's
to
a
decree.
promotion of his application to an Order 38 Rule 5
Sir,
at
I
the
am
appellate
also
stage.
saying 5.42 crores. I'm also two reasons why I'm
Mine
saying
is
this.
9 crores. Mine is 9 crores. So
Two reasons, my lord. Number one is if principal, I'm not insisting on interest, which is in the nature of damages. Number two, commercial sense, a property with an injunction, unsold inventory for even, my lord, 6 months, a year may cause prejudice. So this is easier for a businessman. My lord, it becomes easier for both of us. We go to we go to, my lord, mediation.
You want to
work
take
out-
instruction or you have instruction here?
I have my advocate record. We can come back and take, take instructions and come back. The only thing that uh, uh, worries me at this point of time is the nature of the blanket injunction given in respect of dealing with all the flats in my allocation in a temporary injunction application under Order 39 Rules 1 and 2, where 38 Rule 5 has not been made out.
Mr. Banerjee, since we are contemplating mediation,
Mhm.
let us not fight out immediately. Workable, he's suggesting something, take instruction. If you give bank guarantee, we'll vacate the injunction or altogether.
Bank guarantee to the extent of the principal amount.
5.42.
We also have a claim of 9 crores.
But that you have not filed your counterclaim, have you?
Yes, that's on record. That's on record. So if today my lords are
Counterclaim not yet filed, Lordship.
I'm told that a counterclaim has been placed on record. It is yet to be accepted because an application is required by the learned judge of the court below for that to be formally accepted.
Not accepted as
I mean, but then it's good, bad, indifferent. It's on record. It
Anyway,
has come with the written statement.
Take instruction, come back.
I can take instructions. Otherwise, my lord,
You can come back at 2 o'clock today or on
maybe
Monday.
Maybe on Monday.
Monday. Oh,
Oh,
2 o'clock we are not there.
2 o'clock.
Monday.
Yes, 2 o'clock, a different bench, my lord, that Anand Lok matter review. Finally.
Monday.
trouble my learned friend is brewing up, my lord. I'm sure it.
The appellant, the appellant has come up against this is ad interim ex parte.
No, this is
Final order of
final order of temporary injunction,
Against
allegedly on contest, but actually ex parte.
Against an order of temporary injunction restraining it from dealing with its share, its allocation of flats in the building in question. Stop. Paragraph. After hearing learned advocates for the parties for some time, we are of the view that there is an element of settlement in this matter. Stop. We request learned advocates for the parties to take instruction as to whether their clients are willing to go for mediation. Paragraph. Mr. Banerjee, learned senior counsel representing the appellant, says that the blanket order of injunction is causing huge prejudice to the appellant. Stop. It is after all a money claim. Stop. The question of security should not arise. Stop. Paragraph. Mr. Chaudhuri, learned senior counsel representing the respondent oblique plaintiff, says that his client may be willing to, his client may be agreeable to the injunction order being vacated if the plaintiff's principal claim in the suit is secured by way of a bank guarantee. Paragraph. At the suggestion of learned advocates for the parties, let this matter be listed again on Monday date diye dao to enable Monday. Tuesday date diye dao. Wednesday date diye dao to enable learned advocates to come back with proper instructions.
Grateful.
Item number 9.
Please, Your Lordship, but I'm appearing for the respondent in the matter.
Pass over, appellant not here.
Item number 10.
Please, Your Lordship, I'm appearing for the petitioner in the matter. Let's,
Pass over.
Lordship.
দুটোই পাঁচশো বাড়াতে
Pass over matter. Item number 2.
Here for the appellant. Now, this is a section 37 application. Now, arising out of an order passed under section 9, refusing pass any orders on the ground that my lord, the court does not have jurisdiction.
Where's your affidavit of service?
No, there are, my lord, I just must indicate, my lord, there is one primary respondent who is a signatory, and my lord, there is another pro forma respondent, perhaps against whom, my lord, I am seeking. My lord, I have an innocuous prayer in the section 9 application. My lord, briefly on facts. My lord, a tender is floated by the pro forma respondent, where, my lord, the primary respondent is the principal contractor.
1 second, sir. Let us see if service has been effected.
The service has been effected as against the pro forma respondent. My lord, I show from the records, even in the section 9 application, my lord, they did not appear. So that is why, my lord, this
Pro forma, your relief can't be against the pro forma.
My lord, today my relief is only limited to an inventory of the assets which are lying within the jurisdiction of the pro forma respondent. Because, my lord, criminal cases have been lodged against the primary respondent, he is hiding away. My lord, he is hiding away from law. My lord, he has never appeared before the commercial court at Asansol as well.
The primary respondent is yet to be served, sir.
My lord, kindly appreciates, my lord, he is hiding away. It's very hard to trace him out and to serve, my lord. Even in the commercial court, your lordship will find, my lord, he has not appeared.
Get an endorsement of refusal, whatever, can't be found. It only says
But, my lord,
dispatch.
the prayers I am seeking would not affect his rights. Kindly appreciates that. The prayers what I am seeking, because my
Inventory of-
assets are lying
Where?
within the jurisdiction of the pro forma respondent, who is the main contractor. Let me be very precise, my lord. I was given a subcontract by the respondent. Respondent got the primary contract from the pro forma respondent. It's a government organization. Now, my lord, kindly takes up paragraph.
The 9th May.
There are description of assets, my lord.
এর কাজ করবে না তো কিছু। This track report is of 9th of May. Today we are on the 16th of May. Get another track report. It may well have been served by this time.
না না পৌঁছেছে কিনা সেটা 9th of May. ট্র্যাক রিপোর্টটা তো 9 তারিখে।
This is item dispatched 9th of May.
My instructions are till today, my lord, it has not been served on him.
Where, on what basis does he say that, your advocate on record? On what basis does he say that?
Well, the only difficulty here is, my lord,
Bring an updated track report, that's all.
আনতে হবে তো, সেটা দেখাতে হবে না।
Monday.
Monday একটা নতুন। Lord, may I then take back the affidavit of service?
Yes.
File a fresh one, my lord.
Javi. It's We'll come back.
Passed over matter, item number 9.
ছিল না তো, usual. Give your appearance.
No, will be called. Passed over matter, item number 10.
Yes, he was here in the
He was
first one.
here, like, he has gone praying for a short Passover, my lord, or not today in that
Not
case.
today.
Not today.
Hey,
Babude, continue type thought.
আচ্ছা আপনি কি রেসপন্ডেন্ট ইন্ডিয়ান কোনটা ও আচ্ছা আচ্ছা
কাজে লাগে না যখন কেন রেখে দিতে যাবে
17449
দেখে
নিচে রাখ
একটা হয় ছোট হয়
Original side commercial division, item number 1.
Item number 1, I appeal for the respondent plaintiff.
why is it to be?
At
Yes,
their
sir.
instance.
Sir, I am for the petitioner, sir. Lordship, I pray for kindly allow me to submit the informal paper book beyond the time, Lordship.
When will you file? Today?
Yes, Lordship, I can file.
Time to file paper book. Time to file paper book is extended till today. Key. Time to file informal paper books is extended till May 22. Oh,
His pleasure is to keep the appeal.
paragraph. List the appeal
A week after the vacations.
a week after the summer vacation. Date is the 16 June. The other.
Item number 2.
Has been served. But mentioned quite a few times when it's an appeal from an order.
Your affidavit of service.
Affidavit of service, I'm told, has been filed.
Dakho affidavit of service.
16th April when it was served through mail. Through email when it was served.
The registrar has found the respondent number 2 to be a prior user of the mark.
Yes. Well, what is the procedure adopted by the registrar is in question. That they initially, the respondent number 2 claimed user since 2013. Sorry, 2011. Even in a suit filed by him against me, they claim that they have been using it since 2011. Evidence was filed before the registrar. Arguments were made. At the time of filing written submissions, they change the date of user and make it 2003.
Just serve through email.
Through email. Serve through email.
No,
Well, I can serve.
we don't accept this.
I'll come back after service.
The service is yet to be effected on the we are not happy with the service that is said to have been effected on the respondents. Let fresh service be effected and affidavit of service be filed on the next date. Paragraph Tuesday.
Tuesday. They are in Jorabagan. They can
Tuesday date the other.
Grateful.
Chappan Bhog.
Yes, man. That's also my point. Where Chappan Bhog can't be anybody's monopoly. It's offering to the DT. Neither mine, not there.
Business to dry fruit service.
Yes, makhana, dry fruit.
Oh, Chappan Bhog.
3 and 4.
My lord, in item number. My
So
lord,
there you see, we do our homework also.
In all the matters, I've seen that.
Yes.
my lord, in item number 3, I'm for the respondent. I'm led by Mr. Shorojit De. My lord, on 14th itself, he indicated that he will be out of station till 21st.
That he did.
So, my lord,
Oh,
will
that
it be
matter.
kept on 22nd or after the vacation? Either on 22nd or after the vacation.
Any date convenient to us.
22nd, 2 days before 1 day before the vacation. Let it be there in the list. If it is called, if you want, we can keep it after the vacation, whatever you say.
Let it be on the list, my lord, if you would be available.
On the prayer made on behalf of Haldia Development Authority, Haldia Development Authority, let this matter stand adjourned and be listed again on May 22. May 22, 2025.
My lord, may I seek for accommodation in other matter?
Which matter?
My lord, this is, my lord, in the probate proceeding, where Mr. Mitra is there. He will return on 13th. Your lordship was in my absence that has been fixed on 13th of June. I have been informed by Mr. Mitra that he would not be available on the 13th. And your lordship was...
Which Mr. Abrojit Mitra, Mr. Surojit Mitra?
Mr. Jayanta Mitra, my lord.
Mr. Jayanto Mitra. We have fixed a matter on the 13th of June.
13th
Which
of
matter
June.
this? Abhi?
This is a probate matter, my lord. Your lordship has taken, my lord, in my absence that has been taken, and my learned junior was there. He sought for time, and as a last chance, your lordship was kind enough to give and 13th, and I have been informed by Mr.
Pattern না বললে বুঝবোটা কি করে? নামটা বলুক. What is the cause title? কিছুই one matter. There are hundreds of matters, Mr. Dotto.
It's a Reva Mitra, in the goods of Reva Mitra.
You are not, Mr. Mitra will not be there. Mr. Mitra is...
Mr. Mitra will return on 13th. So
he is leading you or opposing?
He is leading me.
When do you want it?
15th.
On 13th, make that prayer because an order has been passed. So it will appear in the list on the 13th. Ask your junior to come and tell us, we'll adjourn it. Tell your other side also. Who is there on the other side?
Mr. Surajit Mitra is there.
Surajit Mitra, tell him in advance.
Item number 5.
There are two appeals, my lord. Item number 5 and item number 6, my lord, have been led by Mr. Aurik Banerjee, my lord. And he has not come to court because he's not well, my lord. The caution can be adjourned the matter.
But your lordship recalls, my lord, this is the same matter where, my lord, the tenant who is in appeal before your lordships has been enjoying the property from admittedly, from November 2019 without paying a penny. Now, my lord, the appeal before your lordships today is from an order, my lord, dismissing their recalling application.
Can be paid or not, my lord, is on that particular.
We made an application for payment of interim, my lord, occupational charges.
We remember. Thing is that he's saying not well, that would not come to court.
Lord, I appreciate that, my lord. I'm only indicating that even before the learned single judge, similar occasions happened, my lord, where 3 dates they took adjournments.
All 3 days, Mr. Banerjee was unwell.
One date, my lord, the order which they seek recalling of, on that day, the pleading is that Mr. Auric Banerjee had a family medical emergency. The juniors had been caught up in some other tribunal.
We will show it and we'll place it, my lord, the record, my lord.
Not today, but sir, কি করবে?
I'm not
will
standing in the way
place
for
it
an
from the
adjournment.
record, my lord, that
Not
will-
Before
today,
the
not
vacation,
today.
my lord, if it could be before the vacation.
Not today, we are saying.
my lord, if it can be kept on Tuesday, my lord.
Tuesday?
Tuesday.
No problem. But Tuesday, if Mr. Banerjee is unwell,
No, my
you
lord,
better prepare yourself. Yeah.
deeply appreciate.
Fact number 7.
এই বাবা, সেইটা। 700 কোটি, 600 কোটি, 500 কোটি।
May it please your lordships, I'm appearing for the appellant in the matter.
You did put on notice, Mr. Mukherjee, that you will be praying for disbursement of money.
My
And
lord.
Mr. Mukherjee put you on notice that he will be praying for dismissal of the appeal. As this is contrary to some order of court. Yes.
Give me the convenient one.
Yes.
My lord. Lord, we've prepared the convenience volume because this, my lord, appeal runs into 14 volumes. My lord, we have prepared a convenience volume where, my lord, the main documents which will place reliance on, my lord, are, my lord, part of this convenience records.
We have a matter fixed at 12:30.
Matter, we will.
So we will hear you for 20-25 minutes, or if you want, yes.
I have, my lord, only one thing is, my lord, the documents should be, my lord, the documents which were annexed.
Absolutely.
My lord, to, my lord, the petition.
Yes, please.
My lord, because I don't
I'll
know if an
indicate,
index has
I'll,
been handed up.
what I'll do, my lord, I'll also indicate the relevant page in the document.
Mr.
That will, my lord, resolve the issue.
My
But
lord,
we have not annexed anything new. We have not annexed anything.
My lord, I don't know. We haven't received anything as yet, but I don't know if your lordships have an index.
Mr. Mukherjee, this is not going to end today.
No, no, it's not.
So ask your junior to check up.
No, no, that's fine, my lord. Does your lordship?
No index.
No index. We could not prepare the index. My lord, next day, my lord, before we start, we'll
Then
give
why
the-
are you giving this to us?
Point giving it.
No, it is not. I'll indicate, my lord. These documents are all, my lord, part of the records. It's just, my lord, so that your lordships are not required to flip through the pages.
No,
of
no,
the
we
paper.
understand, but do it in a proper manner, Mr. Bag. That's all we are saying.
We'll do so, my lord. We'll do so.
You proceed today.
My
Tell
lord.
us.
Give it with an index, my lord, then
My lord,
we'll know,
what
my lord,
I'll only indicate this. This is paginated. So, my lord, I can.
Very well.
It's paginated, my lord. At the bottom,
Yes.
middle page, my lord, middle of the
Yes,
page.
yes.
That's the pagination which I'll refer to.
Very well.
It's the pagination of the compilation.
Of the compilation.
Yes, but what about the page? My lord, I'm not going to read, my
But
lord,
I'll
one
indicate.
document 5
I'll
times
indicate.
over.
The,
I read
the
14 volumes.
page number of the paper book, perhaps,
Is at the
is at
top
the
right hand side. Top right hand side. So none of these documents, my lord, are additional documents. It all started, my lord. Airdrop it to sir. We'll do it, sir.
No, you're right. নিচে একটা যে number আছে, paper may not be a- Mr. Bag, yes, as my brother points out,
Lordship.
some of the pages, this paper book page number is not there.
I'll indicate, my lord.
What
It's
will
all-
you indicate?
I'll indicate
No, no,
the
no.
relevant page number.
We will indicate. Come to compilation page 440. Compilation page 40.
Page 40, my lord.
Yes. Where's that page number on the top? So this is not a part of the paper book.
It is a part of the paper book, my lord. I'll indicate this is a part of the paper book. This is, my lord, the more clear copy. It's the same document. I'll annex, my lord. I'll indicate where the document is same copy, my lord. It's just that it is illegible in the volume, and this is a more clear copy. Tell me the page number of balance sheet of
all the
2000.
pages starting from that
Yeah, that's
page.
because there are two balance sheets, 2019-20 and
This
2021.
creates confusion. They don't trust you. So
Lord, we will prepare that index where, my
yes,
lord, we will indicate these pages and we'll also indicate, my lord, the relevant pages of the paper book.
yes.
But may I also indicate this? For example, my lord, of the partnership deed, my lord, there are some documents which, my lord, runs into several pages. We have only annexed the relevant page, first page and the relevant page which we are going to refer to. Otherwise, my lord, the convenience volume will no longer remain a convenience volume. It will, my lord, again become one of the additional volumes. But we have tried to do that. We'll put in an index. I think that will resolve the issue, my lord, with the current page number and the corresponding page number of the volumes.
Very
We'll do
good.
that. Pick the balance sheet page number, please. Because the issue is whether this partnership, my lord, deed relates to a, my lord, it is a partnership at will or not. That's the fulcrum of the dispute, my lord, which is pending adjudication. As on date, it's pending adjudication. My lord, the deed, may I first indicate, my lord, it's
Point is not even. I didn't want to interrupt my learned friend, my lord. This point is not even there in this application.
my lord, to give an overview of why this application, my lord, I need to indicate these facts. These are, my lord,
But
the
this is not
this
even
is the
there in the application.
it is. I'll indicate, my lord, because that's the very basis of the, my lord, entire proceeding. If I don't, my lord, explain why this application was necessitated in the first place, and what is, my lord, my grievance as to why I did not, my lord, why the appellant before your lordship, my lord, is praying for this order, which was rejected. My lord, for that, my lord, I have to step back and I'll have to indicate
Has
what.
any competent forum decided on your entitlement to receive this amount?
No, as on date, that is, my lord, that is why my interim application is necessitated. Because, my lord, today there is no competent forum. I'm very grateful, my lord. No competent forum which has decided it. So, my lord, today that is the dispute in the suit. The dispute in the suit is this: plaintiffs say it is not. They pray for a declaration. This is not a partnership at will. We file a counterclaim where we pray for a declaration that the partnership.
We have a takeover call coming to.
Mr. Bach, kindly point out what is wrong in the order.
Because the order, if your lordship kindly takes up the impugned order. But before that, my lord, the difficulty is if I only indicate the order.
Let us have an examination of the order first.
Very well, my lord. May I only request your lordship
first criticize the order on the points beyond to.
My lords. Before that, my lord, I'll indicate the order impugned. Your lordships kindly take up either from the, my lord, the memorandum, or, my lord, it's at volume 14.
We have it.
My lords. With this, kindly take up one document which is necessary, my lord. It's volume 14, page 2001. Because that was our written notes of submissions. So that, my lord, our case and, my lord, the order that is passed. That will indicate, my lord, why that order, because I'll have to indicate why that case was made out.
The written notes will your case will be in your application.
Our case is in our application.
Written notes often
the
travels
brief,
much beyond the application.
It is really, my lord, indicating only the paragraphs which are there in the petition and the documents. My lord. It's an encapsulation of my application and the affidavits and, my lord, the proceedings.
Yes.
Give me one compilation. Now, the order impugned, and for indicating why the order impugned is bad, so that is why I'll take 5 minutes, if your lordships permit me, my lord, to go back and indicate very briefly. I'll not take more than 5 minutes by the clock to indicate, my lord, why this application was necessitated in the first place. But if your lordships want me, my lord, to indicate at the very instance the order, kindly take up the order, but kindly permit me to go back to those facts. My lord, kindly take up the order once. GACOM 9/2024 is filed by the defendant number 1 seeking release of this amount, 2,69 crore required for immediate kidney transplant at the Center for Kidney Diseases PTE Limited, Singapore. Sum and substance of the application is the defendant number 1 petitioner is one of the partners of the registered partnership firm Sherajuddin and Co. having 12.5% shareholding. The firm is in the business of mining and had a fund position of this as on 31st March 2019. Since the defendant number one, petitioner has 12.5%, shareholding is in the partnership firm accounts, a sum of rupees 264 crores is lying in the capital account of defendant number two. The partnership firm also has a fixed deposit of more than 962 crores. It is further pleaded that because of various reasons, the defendant number one petitioner dissolved the partnership firm with a notice of 13 July 2019. Instant suit is filed on the issue of dissolution. Now it is submitted that the petitioner has been suffering from renal treatment and needs substantial amount of money for treatment in so-and-so hospital, Singapore. APO 29/2020 was preferred before the Honorable Division Bench against the order refusing to appoint a receiver passed by the single bench. During pendency of the appeal, the prayer was made by the appellant, being the present petitioner, for disbursement of a sum of rupees 5 crores 79 lakhs. On the basis of the prayer,
Six 9/2022 order of division bench is in the convenience volume.
it is, my lord. 6-9, no, my lord, 6-9 is not there.
Please place that. Place that order first.
My lord, may I only pray for this? If it suits, if it, my lord, is convenient for the honorable bench. May I quickly indicate, my lord, a few orders? The reason is, my lord, if I indicate orders out of context, my lord, then perhaps I'll be failing in my duty to indicate what is the
No, that is something which has been relied on by the learned court. Kindly show that.
Yes, you will show us all the orders you want to, Mr. Bag.
My lord.
First, just show us this order. 6-9/2020.
6/9/2020.
6th March 2025.
6 September. Page 6 of the order.
My lord.
Last paragraph.
Six nine. Kindly grant me a moment. That perhaps is wrong, but it should be 16th 9. That's at volume 7, page 921. Doesn't form a part of this because this is, my lord, the order in contempt. This is the contempt which we say, and that is why the order is bad. But I'll indicate that this contempt order is, my lord, in no way an impediment to the application and the prayers which we are praying for. I'll indicate that.
That's page 470, my lord.
It's 921, volume 7, the same order is, my lord, annexed. It's 16th of September. This is the order, my lord, where we had preferred the application for contempt and the application was dismissed by your lordships. Lord, I need to indicate, I'm sorry. Milords.
Where are your prayers before the learned single judge in this particular case?
In GA9, Milord.
Yes.
Milord, the prayers are, Milord, at page 47, volume 1. Don't show them the comparison.
And what were the prayers in this? The application on the order passed where against you have approached in the appellate court APO 29 of 2020. What were the prayers there in the original
Milord,
application?
APO 29, Milord, it was for appointment of a receiver and Milord, disbursement of 5 crores 79 lakhs.
There was a
there.
prayer in that application.
Milord, I'll have to cross-check once. Milord, the main prayer was, Milord, for appointment of a receiver in GA1 and GA2. May I only indicate this, Milord? GA1 and GA2 was for appointment of a receiver and a disbursal of a sum of money, which was refused. And from there, Milord, there was an appeal preferred. Milord, that is, Milord, the genesis of the contempt order. Milord, the finding of your lordships, Milord, in the contempt is because, Milord, there is an application before the Honorable Court.
That application is still pending.
Pending. It's pending. That today, Milord, my scope is very different. Milord, today, kindly permit me first, Milord, to read the order since, Milord, your lordships wanted to, Milord.
We have to take up the fixed matter now.
May I only indicate one fact, Milord, and then I'll stop, Milord. Your lordships permit me. The case which is being made out by, Milord, the respondents is today you are asking for money. Show me the legal right. If you don't have a legal right, and that's what I am, Milord, given to understand is also, Milord, troubling your lordships. If there's no legal right, how can they ask for this money? I will, Milord, start my submission on the next day and show first the legal rights that we have. And why, my
At,
lord,
at
we are
this stage, what legal right, what legal obligation they
stage.
have?
At this stage, my lord. At this stage, what legal right we have, and also I'll indicate, my lord, the difficulty if this order which we are praying for, my lord, at the ad interim stage, if this is not given, we will not, my client, the appellant will not be in a position, to fight the main battle anymore. I'll indicate that. From the records, it is evident, my lord, if this ad interim order is refused today, my lord, the main suit where this issue will be decided, my lord, the right has to be decided.
In the present application, you have also asked for a direction on the Registrar General to release 50 lakhs.
But I give up that trade, that has already been done.
That has been done.
That is why, my lord, I say that the contempt, my lord, application and the order passed in the contempt proceeding, my lord, is no longer relevant. The only reason I make this submission is because there is a subsequent order of the Honorable Division Bench, whereby, my lord, dint of which this amount has been paid to us. So that is no longer in dispute. And I'll indicate that, my lord, on the next day.
Monday.
My lord, any day, my lord. My lord, only thing I want to indicate, my lord, 50 lakhs we had agreed, we had put it in. My lord, the purpose for which it was to be used, my lord, they had not used. So the court directed them to put it back, my lord, with the registrar. Then, my lord, when they came again with an application, we said we made a commitment by responding to, my lord, the entreaties of the court, my lord, to provide something. So it's lying with the registrar, let it be disbursed to them. So 50 lakhs has gone. My lord, we have no objection with regard to that. And my lord, I'll show how much we paid till now also. And my lord, we have also been paying, my lord, them 10 lakhs a month.
That's something which we are disputing because that memorandum of understanding itself will indicate that.
They might dispute the MOU, but they
well, today the submission.
Are you receiving the money?
Yes.
Money we are receiving, 10 lakhs, but I'll indicate, because these are questions which I need to answer.
Mr. Bagh,
Also, may I only indicate this, since my learned senior friend has just indicated that, they had conceded to this 50 lakhs being given to us. I'll indicate that was not the case,
Good gesture is what
It was
is
not
recorded.
good gesture. It was an order of the court. It was not good gesture. That's what I'll indicate. That's what I'll indicate.
Contempt, my lord, I would have gone.
I'll indicate that. Division bench
From
order.
learned counsel appearing for the appellant resumes his argument but does not conclude paragraph. List the Monday. Monday, Mr. Bagh?
May I only pray for Tuesday, my lord, instead of Monday.
My lord, Tuesday, I have only one difficulty which I have indicated. In case, my lord, I face that difficulty, my lord, kindly account.
Yes, no problem. As requested by Mr. Bagh, list this matter once again on Tuesday.
I'm very deeply obliged.
Call the fixed matter. Tuesday, 20 तारीख.
Non-commercial, fixed matter, item number 4 and 5.
Mr. Ghosh, your leader is not there today?
He's there.
We can release the other matters till recess?
But, one thing only I'll indicate, we had asked them for the cause papers. Your Lordship had said ask them for the cause papers. Now they've refused to give us the evidence saying that you're not entitled to it. That's what the letter is. Now, that's not what the letter says. The letter says that you're not entitled to it. They say, not in that case, let my learned friend.
I don't have a copy.
Correct.
You can take the copies from the department. I don't have.
But I will not have access. I'm not a party to the suit. Not, it's simply this. Not, let me put it this way. I'm saying there's a fraudulent and collusive decree. My learned friend is refusing to give me the evidence saying that you are not entitled to it. That's what his letter is very clearly. Now, my lord, let my learned friend say he will not rely on it later because I will not then rely on the principle of not adverse presumption. Not, I am entitled to say so if he refused to give it. His refusal is not on the ground that he doesn't have it. His refusal is on the ground that you are not entitled to it.
This suit was heard in this court.
Yes, yes.
Suit was in
Yes,
this
yes,
court.
yes.
Suit record.
Either permit me, Lord, either permit me to obtain certified copies because I can't get it. I'm not a party.
We'll ask the records to be produced here.
Yes, do that. Lord.
We'll ask the records to be
Do that.
produced. You can both look into it then.
Very well. Very well.
Hey, Koshi.
I think this is just an excuse to avoid. Please see the letter.
Order দিতে হবে।
No, please see the letter.
Not an excuse. Please accept
Orderটা
it.
দিয়ে
Mr. Mitra certainly can't know whether his client has it. Not please see the stand taken by the advocate. Not please see the stand taken. You are not entitled to it.
Very well. You are. Let
I'm
us
giving you the additional. I am giving you the additional written statement. Not certainly not said so here.
Mr. Bachawat, লেখো তো বাবা। Mr. Bachawat, learned senior advocate representing the, এটা কত নম্বর হচ্ছে? 4 or 5? Non-commercial.
Item 4.
4, acha. Appellants, representing the appellants, says that it is necessary to look into the records of the suit, including the evidence recorded in the suit. Stop. However, since the appellants were not parties to the suit, they may not be able to obtain certified copies. Stop. Paragraph. Let the records of the suit be produced before us.
But please, please, if your lordship doesn't mind, record this that I had asked them for it, and they have said, I'm not entitled.
Why necessary, Mr. Bachawat? Why necessary?
I'll tell your lordship why. Your lordship knows.
We are giving you access.
No, absolutely not. I'm only on this. Your lordship knows matters like this. Not move up. One stand taken, not in writing. That's all. Nothing more. Not the lordship knows. Not these matters. Not as it is. There's an allegation that it's a messy decree.
No, whatever you have written, what the client entitled to.
Obtain certified copies.
Then I
No.
have an opportunity of looking into
No,
it.
order
I have
the
not
records
been able
কেটে দাও।
to,
তার আগে লেখো next paragraph. He further says that his advocate on record had requested the advocate on record for the respondents to supply copies of the depositions. Stop. However, such request has been denied, saying that the appellants are not entitled to copies of such deposition. Stop. This is disputed by learned advocate appearing for the
I am
respondent.
told at 1 o'clock in the morning, this request had come.
1 o'clock.
1 o'clock in the morning, it has come.
That's the follow-up. That's the follow-up.
Follow-up? What
That's the
follow-up?
follow-up.
At 1 o'clock in the morning, you are asking for it and you are saying that give me a copy.
Dekhi.
Let us not get into all this.
We better not.
Let us not get into all this.
No, Mr. Vazir, we will not get into it. This is unnecessarily becoming.
Lord, this is certainly not at 1 o'clock. Lord, I have it here in front of me. Lord, 7:25 in the evening. Lord, may I hand up this letter? 7:25 in the evening.
21:49.
Want to take inspection? I also want to take inspection.
Follow-up was 1 o'clock, but that's
Follow-up.
also unearthly.
Follow-up.
One
We had asked for it at 7 o'clock. Not at 1.
name does anybody send it?
I can't understand these people because they send me judgments at 2:30 in the morning and expect that I would have read it.
My learned friend doesn't sleep at night.
সব কেটে দেবে না।
No, not me. এরা তাই করে। আড়াইটের সময়
ওইটা কাটো। ওই যেখানে আমি বলেছিলাম may not be certified copies, may not be able to obtain certified copies.
Let them be produced. Both parties
Let
will
the
take
records of
inspection.
the suit be produced before us on the next date.
Gotcha.
Huh? You want to continue today?
Pointless doing it. I can, not pointless. Pointless. Let's, because my case, if your
If
lordship,
you have points of law to argue because you have half an hour.
I can do that. I can do that. I can do that. No
You
difference.
want to look at the deposition to
I would.
establish your case of fraud
Fraud.
and collusion.
And collusion. But the case is that defendant number 1 did not give any evidence, sees the lesser. And not the decree goes by admission. Defendant number 2 gave some evidence. That's not recorded in the judgment. Now, I would definitely like to see what that evidence is. Definitely like to see it.
If my learned
Because
friend-
it will.
Definitely, I am not
It will.
standing in the way. If he is entitled to, definitely he will look into it. But then again, my lord, I will also have the opportunity of looking into it.
No,
because
no,
I don't
that's all
have
right. Not,
the change brief which has come to my advocate record. I am not being able to get all the
but my
papers.
learned friend.
No, no, we will both look into it. And if you both permit, we will also look into it.
Yeah, lordship.
May not be necessary if we
Like,
find
so
it
I am
to be
concerned
useless.
permission is granted here and now.
But and my permission is not required. But your lordship, remember, I'd asked for this on the day it was being last
Very
heard,
well.
and they
You
never
want,
said they don't
you
have
want to come back on Monday?
it. Lordship.
এই Monday पे तो पेয়ে যাবে তো record.
But may I suggest something in that case, not instead of
আজকে
keeping
আনিয়ে
it for
নাও।
the last week, but there's already an interim order in all the others for the sheriff not to go till 16th of June. Keep it the other side of the vacation. We can look at all the evidence and come back.
But my instructions are to my lord, have it heard if it is possible for your
Oh, if
lordship.
your lordship,
We can keep it on Monday or Tuesday. We can't promise that it will be heard, but
then-
subject to your learned friends.
no, I have no difficulty. I'll come back. Not if your
Come
lordship
back on Monday.
we'll come back. We'll come back.
List the matter Monday করে দাও। আজকে আনিয়ে নাও তুমি রেকর্ডটা।
Yes, yes.
Or should we keep it on Tuesday so that on Monday your learned advocates on record can take inspection? Maybe better.
But would your lordship permit us to get copies if it's permissible? Not at all. It'll make it easier for us to work.
Immediately just go through the records, don't take copies.
Very.
List করো মঙ্গলবার আর লিখে দাও in the meantime once the suit records arrive, learned advocates on record for the parties will be at liberty to take inspection of the same. So Monday come back. Today he says he'll get the records. Monday এলে দেখিয়ে দিও records. ভাই হচ্ছিল কি দেখে নাও
আপনার দেয়নি, আপনার client না, আপনার কাছে নেই, কিন্তু কাছে তো আছে বটে।
হ্যাঁ অপোজিট হবে না or OD 4 and 5
5 your lordship is my appeal your lordship.
না এটা 4 এ হলো খালি।
We are actually your lordship on the same footing. But Mr. Bachawat your lordship, our application has also been dismissed. So identical appeal your lordship.
Yes, but this order is recorded in our item number 4.
Yes.
5 টা এমনি just adjourn করে রেখে দাও।
Can we take also the lordship the inspection of those particular deposits?
Take inspection.
I'm grateful.
Take inspection. তাহলে তুমি এক কাজ করো, তাহলে 5 এ মিস্টার বাছাওয়াতের জায়গায় খালি বলে দাও মিস্টার সেনগুপ্ত।
But the same order can be passed in the action number 5.
Yes, accepting that Mr. Bachawat will be substituted by Mr. Sengupta.
No, he never asked for inspection at any point of time. He's being inspired.
Okay. Mr. Sengupta, learned advocate, and Mr. Bachawat, learned senior advocate. তাহলে যেটা চলছিল সেখানে ওনারই তো ম্যাটার। Yes, Mr. Mitra, your matter next.
Commercial matter item number 8.
I am the award holder, so my anxiety alert is
In 8?
yes. That's why my anxiety is born. His anxiety is to have it parted. That's what.
No,
I don't mind. I don't mind that. কোথায় বলে এটা কোথায় award then first code normal alert. Award successful first code normal alert. We are here, so I have to
Flaring up. 27% gas had to be flared up.
correct. Correct. That's not whether I flared enough or not. That is As this kind of windfall, naturally, my lord, who doesn't want it? Who doesn't want it? My lord, on the last occasion, I had been placing before your lordship after a part of the award, and thereafter, my lord, some of the pleadings of the parties. And I have submitted to your lordship that that particular observation in the award perhaps was not correct. Your lordship will please to come to back to the award once more, just to recapitulate.
Compilation টা দিও।
Compilation হচ্ছে যে দুটো ইয়ে রয়েছে। Page 19, my lord, the award starts, and I have shown to your lordship, my lord, these two paragraphs at page 205, or rather para 205. At I've shown to your lordship, my lord, at page 100, para 207. This is perhaps not correct recording of facts. Page 207. In the instant case, para 207, page 100. In the instant case, apart from claiming specific performance of GSPA, the claimant has prayed for damages in paragraphs 48, 49, 52, and 53. It has also been argued that its case for damage on account of MGO till the tenure of the agreement, that is 30th April 2034, pleaded in paragraph 48, 52, and 53, which has not been denied by the respondent in para 83 of the SOD. In para 52, it has pleaded that even after termination of the contract by the respondent by its notice dated 7th July 2014, it has raised MGO invoices on and from 1st October. Then, my lord, your lordship will please to come to, and I have shown to your lordship that in para 82, specifically this has been denied and disputed. Now, my lord, I would request your lordship to, my lord, come to para 207, up to 216, I have shown to your lordship. My lord, kindly come to para 209 at page 101. Considering the case of the claimant and the respondent and the materials on record and the conclusions which have been reached by the tribunal, this tribunal holds that the claimant is entitled to a declaration as prayed for in clauses G, H, and I of its prayer clause at page 63. But considering the nature of the contract, this tribunal is in its discretion cannot give specific performance. Now, my lord, your lordship will be pleased to find in volume 1, the prayers have been set out, G, H, and I. The court thinks that G, H, and I should be allowed. This your lordship will be pleased to find in volume 1, page 42. In 41G and 42H and I. If your lordship can take the first volume, G is the prayer, a declaration that the contract agreement for gas sale and purchase agreement dated 11th May 2011 is valid, subsisting, and binding upon the parties. Then H is declaration that the termination notice dated 7 July 2014 issued on behalf of the respondent is illegal, null and void, and is liable to be cancelled and are declared void. And I is declaration that the respondent has committed breach of the gas sale and purchase agreement and accordingly is not entitled to claim or deduct or adjust any amount from the sum claimed by the respondent from the claimant in any manner whatsoever. This, my lord, these are the prayers which have been the tribunal thought that they can be allowed. Then, my lord, the tribunal had, my lord, put a, so to say, some kind of a reservation here. But considering the nature of the contract, this tribunal in its discretion cannot grant specific performance of the same. The tribunal, however, permits the claimant to remove its underground gas pipeline from the premises of the respondent upon giving it 7 days clear notice. Well, I pause here for a moment. I will request your lordship to remember this particular sentence of the in the award. The tribunal permits the claimant to remove its underground gas pipeline from the premises of the respondent upon giving it 7 days notice. This has been repeated again. I shall show to your lordship. Then para 210. It is an admitted position that CBM gas being natural product cannot be stored. It has to be distributed to its consumer or it has to be flared up. In the order of the CCI at paragraph 67, it has been found factually once the CBM is produced and if the consumer fails to offtake the contracted quantity, GECL has no option but to flare up the gas. There is no spot market for CBM gas where GECL can sell the gas which is not consumed by the customer. Now, my lord, my respectful submission will be this particular observation of my lord, the CCI.
This was just a recording of the submission made by them.
Absolutely.
This is what you said.
And my lord, I will submit to your lordship that this becomes immaterial when I have specifically pleaded that there is an alternative market in which they sold the, and that should have been an issue. And that, my lord, on that evidence should have been allowed to be led. I shall show to your lordship the evidence has been shut out on that. My lord, kindly take the award once more, page 101. In paragraph 41 of the judgment of CCI, it has held. Kindly note this. This is also very, very important. Further, quote, further, GECL has to flare up to 28.48% of the gas produced in 2015, 2016, as it had no market for the same in the face of competing products. So, my lord, the tribunal has proceeded on the basis that paragraph 41 of the judgment of CCI has come to the conclusion, the CCI has come to the conclusion that the GCL had to flare up this. I shall show to your lordship that this is not the finding. So, my lord, the very foundation, the very basis of the finding of the arbitral tribunal, my submission will be is wrong, is erroneous. Then, my lord, kindly come to next paragraph, page 102. Next paragraph, paragraph 212. These findings of facts were affirmed also by the High Court as noted above. I shall show to your lordship that this is not correct. This is also an incorrect recording of fact. The learned counsel for the respondent has not questioned such finding of fact and argued on the basis that the said findings are binding on this tribunal. In fact, the learned counsel for the respondent has no choice other than accepting that finding of fact. My lord, kindly note these words, my lord, that finding of fact by the CCI is binding in view of section 61 of the Competition Act. Well, I am seriously questioning this. Section 61, your lordship will be pleased to see what it says and what is binding in respect of the Competition Commission's order. These finding of facts are totally irrelevant. And in fact, my lord, they are not finding of facts, first of all, and you have treated it as a finding of fact, and you have said that in view of section 61, it is binding upon you. I submit to your lordship, it is not a finding of fact. Secondly, I say it's a wrong recording, that's a finding of fact. And thirdly, I say you have read wrongly section 61 of the Competition Commission Act. Therefore, my lord, this is the very foundation of the finding of the tribunal. My respectful submission is wrong. Then, my lord, which says, which excludes civil court's jurisdiction in respect of any matter which the commissioner of the appellate tribunal is empowered under the said act to determine. Kindly, my lord, note this. I'm a competition commission. Since, my lord, we are on this, my lord, kindly take the Competition Act. If your lordship doesn't have it, I shall give your lordship a copy. I will request your lordship, my lord, to come to a few of the sections. Yes, kindly come to section 4. Section 4 of the Act. See, my lord, the scope of inquiry before the Competition Commission. Prohibition of abuse of dominant position. Section 4 is abuse of dominant position. No enterprise or group shall abuse its dominant position. Then subsection 2, there shall be an abuse of dominant position under subsection 1 if an enterprise or a group, either a group A directly or indirectly imposes unfair or discriminatory one condition in purchase or sale of goods or services, or 2, price in purchase or sale, including predatory price of goods or service. Then, my lord, explanation is again for the purpose of this clause, the unfair or discriminatory condition in purchase or sale of goods or service referred to in subclause 1, and unfair or discriminatory price in purchase or sale of goods, including predatory price or service referred to in subsection 2, shall not include such discriminatory condition or price which may be adopted to meet the competition. So, my lord, competition is permitted, and in order to avoid competition, if that is done, then that will not be, as per the explanation, my lord, an abuse. Then limits or restricts production of goods and provision, then technical scientific development, etc. My lord, I'm not troubling it. Then indulges in practice. Kindly see the nature of the inquiry. Indulges in practice or practices resulting in denial of market access in any manner, or makes conclusion of contracts subject to acceptance by other parties of supplementary obligations which by their nature or according to commercial usage have no connection with the subject of such contract. Then uses its dominant position in one relevant market to enter into or protect other relevant market. Then explanation has been given. Then the meaning of predatory price, that has been defined. Then group also has been defined. Now, I submit to your lordship, the scope of inquiry before the Competition Commission is very limited. It is for the purpose of ascertaining as to whether a particular contract has been entered into, wherein one party has been in a dominant position, and taking advantage of the dominant position, it has exercised undue influence on the other party for the purpose of, my lord, concluding that particular deal. And that amounts to abuse of dominant position. And that is what has been said. Then, my lord, your lordship will kindly come to section 19. Inquiry into certain agreements and dominant position. I shall show to your lordship this is exactly what the Competition Commission did in this facts of this case. Inquiry into the certain agreements and dominant position of enterprise. 1. The Commission may inquire into any alleged contravention of the provisions contained in subsection 1 of section 3 or subsection 1 of section 4, either on its own motion or on receipt of any information in such manner and accompanied by such fees as may be determined by regulations from any person, consumer, or association or trade association, or a reference made to it by the central government or the state government or a statutory authority. Without prejudice to the provisions contained in subsection 1, the power and functions of the Commission shall include the powers and functions specified in subsection 3 to 7. And see, my lord, what are the powers? Commission shall, while determining, what is the determination? Whether an agreement has an appreciable adverse effect on competition under section 3, have due regard to all or any of the following factors. So, therefore, the inquiry is to find out as to whether an agreement has an appreciable adverse effect on the competition. And, my lord, in order to arrive at that finding, my lord, A, B, C, D, E, F. Then, my lord, 4. The Commission shall, while inquiring whether an enterprise enjoys a dominant position or not under section 4, have due regard to all or any of the following factors. Then, my lord, the Commission inquires into the market share of the enterprise, then size and resources of the enterprise, then size and importance of the competitors, then economic power of the enterprise, including commercial. Well, this is the exercise that they do. They do not go into, my lord, the adjudication of disputes between the parties. This is what they find out as to whether, under the Competition Act, as to whether the agreement which is sought to be challenged, and in this case, my lord, this agreement was challenged by an employee of, my lord, my client. And, my lord, the issue was as to whether this particular agreement has been entered into with that particular MGO clause for up to 2034, it will be valid and all that. Whether this particular agreement, in the matter of execution of it, whether one party has dominated the will of the other party for the purpose of stultifying competition. This was precisely the inquiry which was, my lord, which fell for consideration of the Competition Commission of India. And, my lord, with regard to the price, with regard to the MGO clause, with regard to everything, my lord, this particular and very detailed inquiry had been made. Then, my lord, kindly come to section 26(1). My lord, I am not troubling your lordship with subsection 5. Kindly see, my lord, subsection 5 of section 19. For determining whether a market constitutes a relevant market for the purposes of this Act, kindly note the words, for the purposes of this Act, the Commission shall have due regard to the relevant geographic market and relevant product market. This is the inquiry. The Commission shall, while determining the relevant geographic market, have due regard to all or any of the following factors. Then regulatory, trade barriers, local specification requirement, nothing to do with the dispute between the parties. Adequate distribution facilities, transport costs, language, consumer preferences, need for, my lord. This is the inquiry that they, my lord, they undertake. Then, my lord, relevant product market. These are, my lord, the factors which they take into account. Then, my lord, kindly turn to see, my lord, the nature of the inquiry. Procedure for inquiry is section 26. Procedure for inquiry into under section 19. On receipt of a reference from the central government or a state government or a statutory authority, or on its own knowledge or information received under section 19, if the Commission is of the opinion that there exists a prima facie case, it shall direct the Director General to cause an investigation to be made into the matter. In our case also, Director General was directed, and he made an inquiry, and, my lord, they found that there was, and in the matter of execution of this, there was infraction of the provisions of this Act, and therefore it held against my learned friend's client in favor of the company. But, my lord, that was overturned by the CCI. The Competition Commission of India, my lord, when they heard the matter by way of an appeal, that was reversed. Then, my lord, the matter went to the Delhi High Court by way of an appeal under the provisions of this Act. Delhi High Court sustained the order of the Competition Commission of India, all on the ground as to whether, in the matter of execution of this particular agreement, GSPA, as to whether there had been infraction of section 3 and 4 of this Act. Nothing more, nothing less. So, my lord, this finding of fact which the tribunal had been referring to, I respectfully submit to your lordship, perhaps either there had been an erroneous understanding of the scope of this particular Act, or, my lord, I will respectfully submit to your lordship, there is, my lord, a complete misunderstanding as to what, my lord, the Competition Commission of India had spoken. And the entire case turned on this. Then, my lord, kindly come to see subsection 3 of section 26 inquiry. The Director General, who is the first tribunal which inquires into the matter, the Director General shall, on receipt of direction under subsection 1, submit a report on his finding within such period as may be specified by the Commission. The Commission may forward a copy of the report referred to in subsection 3 to the parties concerned, provided that in case of investigation is caused to be made based on reference received from the central government or the state government. I'm not troubling your lordship. Then 5. If the report of the Director General referred to in subsection 3 recommends that there is no contravention of the provision of this Act, the Commission shall invite objections or suggestions from the central government or the state government or the statutory authority or the parties concerned, as the case may be, on such report of the Director General. 6. If after consideration of the objections and suggestions referred to in subsection 5, if any, the Commission agrees with the recommendation of the Director General, it shall close the matter forthwith and pass such orders as it deems fit and communicate its order to the central government or the state government or the statutory authority or the parties concerned, as the case may be. Then 7. If after consideration of the objections and suggestions referred to in subsection 5, if any, the Commission is of the opinion that further investigation is called for, it may direct further investigation in the matter of the Director General, in the matter by the Director General, or cause further inquiry to be made in the matter, or its proceeds or itself proceed with the further inquiry in the matter in accordance with the provisions of this Act. If the report of the Director General referred to in subsection 3 recommends that there is contravention of any of the provisions of this Act, and the Commission is of the opinion that further inquiry is called for, it shall inquire into such contravention in accordance with the provisions of the Act. My Lord, I will request your Lordship, my Lord, to keep in mind that the inquiry is confined absolutely, my Lord, under section 3 and section 4. Nothing more, nothing less. Issue is whether there has been an abuse of the dominant position, and that is the scope of the inquiry of this particular commission. And if that is so, to what extent the tribunal, arbitral tribunal, could have relied upon it for the purpose of, my Lord, finding out as to whether there has been a burning out, a flaring out of the gas. This is the short issue. And my submission will be that perhaps the tribunal had completely misunderstood, with the greatest of deference to my Lord, the tribunal, has completely misunderstood the scope of inquiry under the Competition Act, and had, my Lord, erred in, my Lord, relying upon the competition, my Lord, the order of the CCI and the Delhi High Court for the purpose of coming to a finding against my client in this case. Here, my Lord, is a question of assessment of damage. Nothing specific performance has not been granted. Therefore, assessment of damage, nothing more, nothing less. How can, my Lord, Competition Act come into the picture? I will make my submissions with regard to, my Lord, the various findings which had been given by the Competition Commission. I confine my entire submission on this issue. Nothing, I am not going to, my Lord, take your Lordship, my Lord, to the other issues which have been held against my client. I am not entitled to, my Lord, question it before your Lordships, the tribunal's finding of facts. But, my Lord, I am questioning this as to whether they could have arrived at the quantification of damage, that any reliance could have been placed upon the Competition Commission of India or the Delhi High Court. And that is what they have done, which, in my respectful submission, erroneously.
Monday or
Lordship?
Mr. Mithru, Learned Senior Advocate representing the appellant, resumes his argument but does not conclude. Or do you want it? No, second half. Sorry, this bench is not there in the second half. Paragraph lists the matter once again on Monday. এটা নাও এটা একদম টপিক যেন থাকে Huh?
করে দেবো কি হবে
মানে কন্টেম্প ম্যাটার মানে
Contempt. Appellate side.
Yes.
নিয়ে নাও কি আছে? Yes.
To relaxation bail condition, it is assigned, but it is not been listed.
Assigned to this bench. Assigned to which bench? What is the name, cost title?
Rakesh Raki versus State of Wealth Records.
তুমি তো পারবে। কে আছেন অ্যাপেলের চাইতে, কে দেখছেনটা কে? তো নিয়ে নিন, বলছে অ্যাসাইন ম্যাটার, অ্যাসাইন টু দিস বেঞ্চ, রিল্যাক্সেশন অফ কন্ডিশন অফ বেল, এই বেঞ্চটা একদিন কনস্টিটিউট করে ম্যাটারটা দিয়ে দিন, নেক্সট যেদিন বসবো।
Your Lordship, may I be allowed to?
After vacation, madam, not this side of vacation, immediately after vacation.
Your Lordship, may I be allowed to mention one contempt application?
Contempt, this bench.
Sir, my lord, may I be permitted to mention, my lord, contempt application. In the last order, there was a direction through the matter will appear on 10th April 2025. The matter didn't appear before.
Give the slip.
I'm handing over the slip.
Duck.
Item number 1.
Appellate side matters, item number 1.
Matter I appear on behalf of the respondent matters. So by lords, the above matter is the applicant is not interested, because of that the order has already been complied with.
You are for whom?
I was the initially bid petitioner. The applicant who has filed the review, I responded matter.
Device is the writ petitioner.
While the Kakuli Shah is the writ petitioner against the order of the honorable single judge, they prefer an appeal. Appeal is by your lordship. Then they have filed a review application. So now last one, second term, the
Lekho to, lekho.
second term, may your lordship.
On May 2, 2025, on May 2, 2025, accommodation was sought for on behalf of the review applicant. Stop. We had adjourned the matter. Stop. Paragraph. Today, nobody appears for the review applicant. Stop. Paragraph. Yeah, dismissed. Dismissed.
Last occasion, your lordship asked for the review application is pending or not in the tribunal, my lord. I have.
They have already complied with the lordship.
Hey, Dako Rekta.
Item number 2.
Item number 2.
My application, my lord. On the last occasion, my lord, on 25th of April, the matter was taken up. And lordship sees, my lord, there is an order to that effect, my lord. But we had filed a supplementary affidavit, my lord.
Nobody is appearing. Pass it over in the first call. What can we do? Mr. Banerjee was appearing.
Yes, my lord.
Has he come to court? Have you seen him today?
I have not seen him, my lord.
So what should we do? Not today or pass it over?
The only thing, my lord, is there was a liberty to file the response to the supplementary.
Correct.
That has not
Liberty
been
granted
received
to
by
the alleged contempt nods.
Yes, my lord.
So he is representing them.
Yes, my lord.
So unless he is here, how?
Lordship will then pass it over, my lord.
Pass over. Try to contact him, go out,
I
call
am
him.
trying, my lord.
Pass over.
82.
Item number 3.
Three Lordship, I beg to appear on behalf of the Mahesala Municipality Chairman, Contempt.
My lord, I am appearing for the applicant petitioners.
Lordship was kind enough to direct us to file, my lord, report. My lord, the hearing for substituted person of Kaminiwala Bor is fixed 28th May of this month.
28th May for hearing.
Hearing means, my lord, hearing means, my lord, that the demolition took place, the property located at a, my lord, the vested land and unauthorized construction. They are claiming for, my lord, the compensation. Lordship was kind enough to allow, my lord, them to go and ventilate their grievances before the Board of Councillor. And when the Board of Councillor was in session, Board of Councillor come to know, my lord, the Kaminiwala Bor died. They failed to produce any papers and document. At the first instance of their, my lord, the contempt application, hearing was conducted by the Board of Councillor. Then, my lord, the second round of contempt application, Lordship directed them to, my lord, effects substitution. Then substitution taken place and handed over a copy of contempt application to us. And, my lord, immediately, my lord, we have decided, my lord, to...
Very well. We'll keep this immediately after reopening.
Reopening, my lord.
Let us see what happens on the 28th of May. There's a notice of hearing. Go and attend the hearing.
Lordship, I shall go,
Yes.
but before that, my short submission. This affidavit, what have been stated is totally false affidavit. I want to file a affidavit in this regard.
File. This will never end. File.
No.
Keep your
Affidavit filed on behalf of the alleged contemners is be kept with the records. Stop. Paragraph, learned advocate for the petitioners has received a copy of the said affidavit. Stop. He wishes to file a response to such affidavit. Stop. Let such response be filed within a week after the summer vacation. What? 1 week after summer vacation?
Within a week after summer vacation.
That is what I said.
Yes, my lord.
Has your approval?
Yes.
Paragraph lists the matter thereafter when this bench again assembles.
Yes. I'm grateful to your lords. Grateful.
Keep your...
I'm grateful.
Grateful.
After summer vacation. পরে ম্যাটারটা কল করো 3-4 একসঙ্গে আইটেম নাম্বার 5 দেখে নাও
Item number 5. Yes, my lord.
Although I am appearing on respondent number 11 in person.
Yes. Where are the other parties?
That is the entire problem, my lord, that the now today is the date fixed and all have been served and all have given their written objection. We
Yes.
have given reply to it. Therefore, my lord,
Srodhikari, I think the problem is the heat. The temperature.
problem is the heat.
Yes.
Maximum heat.
So kindly come back immediately after the vacation. Immediately after the vacation. We will record an order. We will record an order. Lekho, shiggir lekho. You are for?
Respondent number 11 in person.
Acha. Apart from the respondent number 11 who is appearing in person, comma, no other respondent is represented today. Stop. Paragraph, Mr. Vijay Adhikari, comma, learned senior counsel appears for the petitioners. Stop. He expresses his grievance that the respondents are not present. Paragraph, let this matter be listed once again immediately after the summer vacation when this bench assembles. Stop. Mr. Adhikari's advocate on record is requested to serve a notice on the learned advocates for the other respondents, non-appearing respondents, intimating that if on the adjourned date they are not, the said respondents are not represented, comma, the matter may be proceeded with in their absence.
I'm deeply offended.
Item number 6.
Item number 6, I'm appearing on behalf of the contempt number 1.
I am for the petitioner, my
I am
lord.
for
My
the alleged
instruction
contempt
is this.
Director of Local Bodies.
My instruction is this, my lord, pursuant to lordship's previous direction, my lord. They have started my pension. I am receiving my pension month to month. But so as far as the post facto approval was given to my appointment, my lord, because I have retired in the year 2015, then from 2015 August till date, the arrears which has accumulated over the years, my lord, that has not been paid. Because my post has been approved and they have started disbursing pensionary amounts.
So it has been approved with effect from June 1, 1st June 98.
98.
Yes.
Post facto approval has been provided.
Yes.
Then, lordship, I have retired in the year 2015 August. Then my arrears also, my lord, has to be paid, but that has not been paid. But they have paid the previous month's pension. They have paid the previous month's pension, but arrears have not been paid.
Well, I am for the alleged contempt local bodies. But the appropriate authority for disbursing the arrears, municipality.
Who is for the municipality?
Well, the municipality
But
is not the
municipality is not the part of the contempt because the direction was upon the authorities.
That's true.
Director of local bodies and the state government, and they were the appellants.
That's true.
Communicate. Oh.
But
To
difficulty is well,
But in our order, we have asked to disburse the area also.
Yes,
Uh,
My lord, as per
arrears
the-
are there because
No, areas may be there. Show us the order. Did we specifically say that areas are to be paid?
From June, from any date.
The order.
Accordingly, we agree the conclusion reached by the learned single
Well,
judge. also
lordship's
we
order is at
agree with his lordship.
Order dated 23rd? No.
23rd February, March.
No.
No. Order 13th of October.
13th of
2023.
October. Yes.
Your lordship's order at the penultimate paragraph is page 100, paragraph 31. Accordingly, we agree with the conclusion reached by the learned single judge. Although we disagree with its lordship's reasoning, we therefore do not interfere with the order under appeal. We affirm the operative portion of the order direct the appellant to release pensionary benefits of the
In terms of the order of the learned single judge. Where is the order of the learned single judge?
and single
Single judge.
page 58.
58.
Yes, 50, sorry, start from 48 of the contempt application. And the penalty.
penultimate paragraph is at page 55. In the above conspectus, this court finds it is apposite to direct the respondent authorities to process the pension
The
case of the
pension
petitioner and sanction
Sanctions
the
entered,
intellectual dues
which
it
is
is
admissible.
admissible to
It's
him
area problem.
upon completing the necessary formalities and issue pension payment order accordingly. While disposing of the pension case, the petitioner concerned respondents is also directed to issue post facto approval.
To process the pension case of the petitioner and sanction his entire return due, which is admissible to him upon complaint. So it includes area also, according to me. Don't know whether my brother will agree.
Yes. Who will pay? Or you all go to jail?
My lord, Lordship, my lord, kindly, my lord, I'm my lord, suggesting to my learned friend, kindly add the as a contempt to the municipality. So, what the appropriate authority for disbursing the area of the municipality. Firstly, my lord, we are the approving authority for appointment. We have done. Thereafter, pursuant to lordship direction, our fund was allotted to the municipality, and based on that, the PPO was issued and pension has been sent. And PPO was issued by the director of pension and provident fund. But the difficulty is the area.
Complied with, partly complied with, full
We have no scope to give area. We have no authority.
You are the?
We are the director of local body.
He, who is he?
Well, he is the finance department.
Finance department. As per
Government.
the DCRP scheme of municipal.
You are the government of West Bengal?
Yes, sir.
Who is the contemnor?
Contempt is all the government authorities, municipal.
Who is the finance secretary now?
What one is?
But the cost title says Manoj Pant.
That was the rectified pursuant to lordship leave granted by this honorable.
Acha.
And my lord, so far as my learned friend's submission is concerned, my lord, at the time when the order was passed, both by the honorable single bench and affirmed by lordship's order, they have never stated that arrears will be paid by the municipality and we will be only contributing.
Well, not only
Now at this juncture,
why?
when the order has been directed, my lord, for payment and they have issued this letter.
Who is paying the pension?
Municipality.
Municipality, my lord.
Municipality.
I don't know.
No. If the municipality is paying the pension, then the arrear will also be paid by the municipality.
But the direction is upon the local bodies and the state government.
Doesn't matter. Doesn't matter. You're accepting your pension from the municipality.
But my lord, I am, my lord, so far as
No.
is concerned.
You are accepting it,
I am
Mr. Roy.
I have just received
So,
previous month's pension. I have accepted.
yes, therefore,
But so far as the arrears is concerned, my lord, that is also I'm entitled.
right to the municipality. You have not made them parties here.
My lord, order was initially upon the state government. Lordship, kindly see Lordship's order at the division which order has passed clearly upon the state respondents.
But the rule says
Municipality was there, but order was upon the government.
Respondent authorities. Yes, respondents authority and not been whether the municipality party in that petition or not.
Malad, kindly see.
Directly
Kindly see the
appellate.
direction.
Malad, kindly see
Appellants
that.
are the state government.
Rule 31.
Who were the appellants?
Appellants, my lord, were the state government. No municipality, municipality never preferred any appeal.
State of West Bengal.
Yes.
Then
Malad, kindly see the rules. Malad, who is the
forget about it. There's a division bench order, Mr. Pal. You have not challenged that order before the higher forum. So either comply with it or go to jail. Your client, not you. Very simple. We are not going to change this order now. You should have challenged the order before the Supreme Court then. You were the appellant, and we have, rightly or wrongly, we have directed the appellant. Actor record kuri order? No, sure. Learned advocate for the contemnor, for the petitioner, says that he has started receiving pension. Stop. However, arrear pension has not been paid. Paragraph. Learned advocate for the director of local bodies says that his client is not the authority for disbursing pension or arrear pension. Stop. Paragraph. Learned advocate for the state also makes the same submission. Stop. However, the state's submission is not acceptable to us. Stop. The state was the appellant in the appeal where the order in question was passed. Stop. This bench had directed, upon affirming the order of the learned single judge, had directed the appellants, being the state and its officers, to carry out the order of the learned single judge. Stop. This would include payment of arrear pension to the petitioner whose appointment has been approved post facto with effect from
1998, my lord.
Date.
1st June 1998.
June 1, 1998. Stop. Paragraph. The learned advocate for the state says that the municipality should be directed to pay the arrear pension. Stop. The municipality is paying pension to the petitioner. Stop. Paragraph. We are not concerned with who is going to pay the arrear pension to the petitioner. Stop. Our direction was on the appellants, meaning thereby the state. Stop. That order was not challenged before a higher forum. Stop. That order has attained finality. Stop. It is the duty of the state to sort out the issue with the municipality. Stop. Whether it be the state or the municipality. Now, as per our order, it is the state's primary liability to pay the arrear pension to the petitioner. Stop. However, if the state and the municipality can come to an understanding, we have no objection if the municipality disburses the arrear pension to the petitioner. Paragraph lists the matter once again after the summer vacation, as and when this bench assembles. Huh? Mr. Pal, understand, we have directed the state. State should sort it out with the municipality now.
Item number 7.
My lord, I appear on behalf of the petitioner. My lord, the order has been complied with. Block development officer passed the reason order in favor of the petitioner.
Oh.
and also issued the prescribed format. It is required to be filled up and submit to the authority, and also submitted by the petitioner. But one pending document is pending. that is
Give
the
it. Learned advocate for the petitioner says that the order in question has been complied with by the alleged contemnor. Stop. A reasoned order has been passed by the alleged contemnor, which favors the petitioner. Paragraph, in view of the aforesaid, comma, the CC, the CPAN, such and such, stands disposed of.
Item number 8.
Lord, I am for the petitioner. My lord's order is partly compliant, not fully compliant.
Partly.
My lord, kindly comes from a last.
Then this application is partly disposed of.
My lord's direction was to consider the representation regarding the unauthorized construction. One of the municipality held this is unauthorized construction and directed the parties to demolish. In default, they will demolish. So my lord, that part not been complied with. My lord's direction was specifically, my lord's direction was that, my lord, kindly comes to page 4, my lord's order. If the board of councillor of municipality finds that any illegal construction has been.
One second. Order dated?
Order dated, my lord, 18 January 2024. Page 4, my lord, the top paragraph. If the board of councillor of the municipality finds that any illegal construction has been made by the appellant herein or private respondent in the writ petition, the municipality shall deal with the same in accordance with law. Now, my lord, kindly.
Who is for the municipality?
I am appearing for that.
Yes, what is your instruction?
My lord, I have handed over the entire my lord, order sheet and the other steps we have taken by the compliance order. My lord, subsequently, my lord, the challenging this order passed by the municipality, they choose to file an appeal under section 218. The appeal number is 1 of 2025.
Oh.
Civil court.
Against the order which records illegal construction and demolition, who has filed an appeal?
The parties, one of the parties.
The appellant before my lord's filed, that demolition order passed against them.
I'm handing
They
over the
prepared an appeal.
Still, application was filed, but that was not served upon us. But there is
No, so therefore now, Mr. Mondol, Mr. Mondol, no, Mr. Ghosh, Mr. Mridal Karti Ghosh, sorry. Mr. Ghosh,
as of today, there is no stay in the demolition order. Mere filing of an.
How it is? It is a draft copy or something like that.
Here is the notice, my lord.
what is this?
It is then.
What is this, sir?
It is then.
What is this?
This is the copy of.
You are handing up to a division bench in the High Court?
My lord, this is the notice, my lord, we have received.
What is this?
This is the copy of the plan of the appeal.
With corrections?
That was served upon us.
This was served on you?
Yes, sir. Yes, the seal.
ফেলে দাও।
ওটা যা।
Direction দিয়ে দিতে হবে, appeal টা তাড়াতাড়ি, time bound, huh? Mr. Ghosh, let us do this. Order has been passed by the Board of Councillors, finding there are illegal constructions and demolition is required. One aggrieved party has filed a statutory appeal. You can't stop that. So we'll dispose of this application by recording all this and by directing the appeal to be disposed of as soon as possible, preferably within a time period. And we will further say, in the event the appeal fails, the municipality will carry out the demolition.
We are bound to carry out.
You are, yes. Esho. Nobody, this is your application.
My contempt application.
Oh.
Sunandan Man.
Who is Pranab Das?
Pranab Das is the chairman of the meeting.
I am
Chairman. This contempt application was filed alleging violation of a judgment and order dated January 18, 2024, passed by this bench. Where is that order? Yeah, January 18, whereby FMA 260 of 2023, bracketed the Raju Manna versus Srimati Shunanda Manna and others, bracket close, was disposed of The operative portion of the said order reads as follows. Page number or nahi. এই যে flag তো অনেকগুলো আছে এবার। আচ্ছা, pink flag সবুজটা তুলে নিচ্ছি। ঠিক আছে, pink flag, internal page 3 or 4, ঠিক আছে। Paragraph. The respondents in the appeal have filed this contempt application alleging violation of that order. Stop. Paragraph. Today, it is submitted before us that the said order has been partly complied with. Stop. The Board of Councillors of the municipality, which municipality? Of Diamond Harbour municipality, has passed a reasoned order holding that the appellant in the writ petition, bracketed Raju Manna, has made unauthorized construction and the same requires to be demolished. Stop. Raju Manna has preferred a statutory appeal against such order under section 218 of the Municipal Municipal Act 1993.
Both parties wanted illegal construction we have both.
But your client has not preferred appeal.
No.
They will comply with the order.
No, they have also not demolished.
You go and demolish. Who stops you?
And there is injunction order, kindly cease.
That is injunction, then what we can do?
We are restrained by the civil court. This is the order. We are restrained by the civil court.
You show the civil court our order.
But the order is impugned order dated 16 July 2024, passed by the Board of Council of Lavender Municipality be stayed till 6th May 2025.
That covers both. The 16/7 order covers both.
Municipality Board of partly complied with policy.
It is.
Board of Councillors holding that both the appellant in FMA 260 of 2023 and the present petitioners have made illegal construction, which require demolition. Stop. The appellant in FMA 260 of 2023 has preferred a statutory appeal under Section 218 of the West Bengal Municipal Act, 1993. Stop. Paragraph. In the aforesaid factual scenario, we do not see any reason to keep this contempt petition pending. Stop. We only clarify. Now, we request the appellate authority to dispose of the statutory appeal filed by Raju Manna as expeditiously as possible and preferably within 4 months from the date of communication of this order by the present petitioner to the appellate authority. Stop. We further clarify that in the event the appeal fails, the municipality will be duty bound to remove the illegal constructions made by Raju Manna as well as made by the present petitioners. Now, okhane Raju Manna both ke dao, Raju Manna kore stop karo. The municipality shall also take steps for demolition of the illegal constructions made by the present petitioners, in accordance with law. Disposed of.
Appeal case number 1 of 2025.
Appeal.
Case number 1 of 2025.
Appeal statutory appeal bolechi.
Second, civil
Appeal
judge
case
junior
number 1 of 2025 pending before the
second civil judge junior division Diamond.
second civil judge junior division Diamond Harbour.
Yes.
Our order should be placed before the civil court.
Yes.
तीन पे हो गया.
9, 10 action.
Item number 9 and 10.
My contempt application, my lord.
What review application has been filed by the state, my lord?
Yes. Review application test. Let us see the order
Yes, my lord.
first.
Your lordship's order, my lord, page, my lord. Page, my lord, 76, my lord, of the contempt application, my lord.
Can 1, can 2 key issue.
My lord, this order was passed in the appeal filed by the state, my lord.
How much delay? 316 days.
From that day, my lord, till date, my lord, they have not served the copy, my lord. On that day, my lord, they asked, my lord.
Still don't have a copy?
No, my lord. In that day, my lord, before your lordship, my lord, they submit, my lord, supply copy. I supply that telephone number also, my lord. But till date, my lord, review copy. না এনাকে বলা হয়েছিল ফোন নাম্বার দেওয়া হয়েছিল দেয়নি ইন্টেনশনালি দেয়নি intentionally দেয়নি
I'll not
no please
only 2 things, my lord.
you please
One thing, my lord, that your lordship had passed the direction upon the officer, special land acquisition officer, Paschim Mednipur. Instead of that, my lord, Paschim Mednipur, now it has become Jhargram, my lord. So instead of Paschim Mednipur's special land acquisition officer, Paschim Mednipur, it would be, my lord, special land acquisition officer, Jhargram, my lord. The direction was there to initiate the proceedings.
That will solve the problem.
That will solve the problem. One more thing, my lord, and latest development has come, my lord, that the state wants to purchase the land directly, my lord. If that can be, my lord, we have
We
already.
can only say the state will be at liberty to negotiate. We cannot force them.
We have already initiated, my lord, we have been given a permission by the state to direct purchase the suit land.
No,
Only if they agree. Yes.
My lord, that can be done. That to that extent, my lord,
Yes, that we can clarify. We'll clarify that. But give him a copy of the.
Kindly see the order passed by the read court, my lord. They have prepared the appeal, my lord. They have prepared the appeal. When they have prepared the appeal, my lord. Kindly see the date, only one date, my lord. Because they have stated, my lord, in the 17, in the year 2017, my lord, the state was bifurcated, my lord. But in 2018, my lord, they prepared the appeal by Paschim Midnapur.
Very well. We'll simply dismiss. You will never get your money.
No.
Then why are you opening your mouth when it's not necessary, Mr. Mondol? Can one now? Can one condonation. This is an application for condonation of delay of 316 days in presenting an application for review of a judgment and order dated December 22, 2023, whereby MAT 580 of 2018 was disposed of, was dismissed by this bench. Stop. Paragraph now, causes shown being sufficient, the delay is condoned. Stop. Can one disposed of? Can a paragraph can one disposed of? That's a review or can two tax now. The learned advocate for the review applicant fairly states that though this application has been filed as a review application, the review applicant, i.e. the state, is not challenging the merits of the order in question. Stop. The order had directed the Special Land Acquisition Officer, Paschim Mednipur, to initiate fresh acquisition proceedings in respect of the concerned land of the writ petitioners, bracket A, respondents herein, bracket closed, under the 2013 Act, now Act, for the purpose of paying compensation to the writ petitioners and to complete such proceedings within 4 months. Stop. The compensation was directed to be paid to the writ petitioners within a month thereafter. Stop. Paragraph. Learned advocate for the state says that there has been a bifurcation of
the department, my lord. Now it has
of the concerned department, which now falls within the district of Jhargram. Stop. Therefore, the direction should be on the Special Land Acquisition Officer, Jhargram. Stop.
All files have been transferred to the office of the Jhargram.
My lord, but since I have the instruction, so I have to assume that it is within the knowledge of the Jhargram. But না আমার তো ওইরকম মজা
কি বলেছি? Paragraph. We see logic in the submission made by learned advocate for the state. Stop. Paragraph. Mr. Mondol, learned advocate appearing for the respondents oblique writ petitioners, also says that so long as the writ petitioners receive compensation on an early date, he has no objection as to the personnel on whom a direction, a direction is issued. Stop. Paragraph B, therefore, modify the judgment and order dated December 22, 2023 only to the extent that the direction in paragraph 16 of the judgment and order will be deemed to be on the special land acquisition officer, Jhargram, instead of the special land acquisition officer, Paschim Medinipur. Stop. Paragraph. Learned advocate for the state further says that the state is desirous of purchasing the land of the writ petitioners under the direct purchase policy. Stop. We clarify that the state will be at liberty to do so if the writ petitioners agree in that regard. Stop. Otherwise, the judgment and order dated December 22, 2023 has to be complied with. The reviewer can too both disposed of. Then what remains of your contempt, Mr. Mondol?
So, Your Lordship, direct them to complete the proceeding within certain time so that I can file another contempt.
Dispose of it, aage tale bolo.
They will not comply, my lord. So, I will file another contempt.
We therefore direct the special land acquisition officer, Jhargram, to comply with the order, judgment and order dated December 22, 2023 within 4 months. Na, likho, direct to initiate fresh acquisition proceedings in respect of the concerned land of the writ petitioners under the 2013 Act for the purpose of paying compensation to the writ petitioners and complete such proceedings within 4 months from the date of communication of this order. So, the compensation shall be paid to the writ petitioners within a month thereafter. এবারে reviewer can টুটা করে দাও আর contempt নাও এবার দিয়ে বলো in view of the order passed earlier today on the review application filed by the state, we see no reason to keep this contempt application pending, which accordingly stands disposed of. Contempt review.
Pass over matter item number 2. In this matter, I have talked with them. Only I have to file just reply to the supplementary affidavit which has been filed in the earlier occasion. But only
that was
they have said that partly complied with. We will come with that just after the vacation. Keep it.
You come with what?
That partly complied with. They said we will with full satisfaction of your lord.
With full satisfaction.
Not only your lords is with them also.
That we are seeing for last 2 years.
Yes, this is going on, Mr. Banerjee. We also have a limit to our patience.
Then I can open. What happened?
No, don't open. Don't open. You come back with a full compliance report. Otherwise, we will have to.
Only keep it 1 week after victory.
That is all right. That is not the problem. Is Mr. Jain still the commissioner?
No.
Have you brought on record?
Yes. That has been done. But only thing, we have prepared a chart with the lordship sees, I'm giving it to handing over to them also, what is yet to be demolished, my lord?
That is, my lord, goes through it. Block A, 4 flats, flat and garage. In front.
Jaguar car showroom. Jaguar shop.
Fittings,
shop.
fittings.
Oh, Jaguar fittings.
But this garage has to be demolished. One go down. So far as this is to be demolished, we will come.
Likho. Learned advocate for the petitioner hands over a list of constructions, illegal constructions, which are yet to be demolished by Howrah Municipal Corporation. Bracket HMC, paragraph. Mr. Banerjee, learned advocate for the alleged contemnor, oblique HMC, says that he will file a full compliance report.
Supplementary will also will file. That also will file.
Well, supplementary affidavit.
On the next date, as well as response to the supplementary affidavit of the petitioner, which was filed on April 25, 2025. Stop. Paragraph. List this matter once again on HON'BLE, immediately after the summer vacation, as and when this bench assembles. Stop.
1 week after the
It will necessarily be 1 week after.
I think Lordship will make this peremptory order, my lord.
Stop. We make it clear that this matter has been pending for a long time. Stop. On several occasions, assurance was meted out on behalf of HMC that the order in question will be fully implemented in its true letter and spirit, letter and intent. Karo. Stop. It appears that till date that has not been done. Stop. If on the next occasion we are not satisfied that the order in question has been fully executed, we may be compelled to pass very stringent orders against the alleged contemnor. এটা লিখে রাখো, এটাতে ফাইলড আজকে ডেট দিয়ে, ফাইলড বাই দ্য পিটিশনার, হ্যাঁ, এটা লিখে রাখো। হয়ে গেল? ও, তাহলে অরিজিনাল সাইড?
করে দে ভাই।
সি মারবো আমি তো একেবারে এটিএম না আমার
একদম কারেক্ট বলেছি, কিচ্ছু হবে না।
1 and 2. Oh yes, such matter. Item number 1 and 2.
Yes, 3:15, matter should be over. You had said 5 minutes, we remember. Mr. Arindam Banerjee.
If you say 5 minutes, it will be 4 minutes.
That gas will not work.
Exactly what I was thinking. Came out so well.
Yes, tell us. No, please finish today.
Yeah, we try. Appellate side টা আগে।
Yes.
There is one appeal and 2 review applications pending.
Yes.
Regarding the review applications, I will not submit much, my lord. Much has been submitted. There are a few points in which, my lord, we are seeking review. They are within reviewability according to us. But then all 3 are to be taken together for the purpose of a overall view of the matter. Now, my lord, what I'll not, my lord, place the learned single judge's order and then division bench's order, but a brief overview. What exactly played in the mind of the Honorable Division Bench while dismissing the applications, the mats that had come up. There were 3 writ petitions.
Maybe make a suggestion. Conclude your oral submission today, file a written note insofar as the appeal is concerned. By next Friday, file your written note so that today you can be really brief and get done with the hearing.
Of the appeal. As far as the
Review, so you have already made submission, you said.
No, review, I mean, I wouldn't want to address your lordship first on the review, that's what I said.
Do so. You wouldn't want
to first address your lordship on the review. First on the appeal and then parts of the order under review which may stand in the way.
Well, whatever you do it today, Mr. Banerjee. It's impossible. It's becoming impossible for us. And after that, if you want to file notes in review also, file notes. We'll keep the matter only for filing notes on Friday. And today you just indicate your points and complete.
The only one prayer, lordships were wanting to utilize, Lord, perhaps the vacations for disposing of this. Would it be possible for us to file our notes beyond the vacation, or would it be would that maybe file our notes
reopening day
beyond the vacation, so that, my lord, we get
reopening day that we'll grant you, but kindly finish your oral submission today.
Yes. Next Friday this is perhaps the next Friday, my lord, is the last day before vacation.
Yes, only to file the written note. Oh, sorry.
Oh, no, I mean
written
Friday,
note will be reopening day.
Now, my lord, the facts are completely known to your lordships, lord, and to us, my lord. I'm not going to, my lord. The appeal, my lord, which has been set apart for hearing was set apart because, my lord, that was not dealt with in our reciprocal submission in the judgment, combined judgment that was made.
That appeal arose in what background?
That appeal, my lord, arose. There are 3 points of challenge. One was yes, this is MAT 617 of 2023. 2023. 617.
617
of 2023
was not dealt with.
No, my lord, this is now coming up for reconsideration. I mean, so the appeal has been opened now. So we'll be submitting on the appeal. Yes, there's very little scope. Even in the appeal, my lord, the scope is only on a point of law. This appeal arises out of, my lord, an application made for revocation of the new sanction plan which had been granted in respect of the 700 square meters of land. The writ arose because despite filing a representation, the municipal authorities did not dispose of the same. In fact, several representations. What was there in the representations is the central theme which would attract the writ jurisdiction. Otherwise, everything else can go to the civil court. Really, who has right and who does not have right are not issues to be gone into in writ jurisdiction. We presented it and the Honorable Court was pleased to make certain observations regarding that. But later, here, the specific writ was, we had filed an application and then a series of applications. We means the association, saying that the new sanction plan that has been granted in respect of the 700 square meters of land is required to be revoked and or cancelled. Why do we say that? Only for 3 reasons, none of which depends on our title. First, the land on which this plan has been taken to be a site for sanction is already a part of a previous plan in respect of the macro premises.
under the 1951 Act. This is undisputed. No one can say that that land was kept aside and kept vacant for no reason, or that the site did not contain the land. The site presented for sanction contained that 700 square meters of land, on which, according to corporation, there are 3 affidavits which say
Yes.
Now, my lord, as far as the site is concerned, the site contained that 700 square meters of land under the original plan. Our complaint was that after it being subsumed in the original plan, there could not have been a fresh sanction in that 700 square meters. Not to do with questions of title at all. Municipality will not go into questions of title. But if someone comes and applies for sanction of a plan in respect of a portion of the premise, number 227, saying that this is a separate portion available for me to present for sanction, we are striking at that route. We say that there are 2 provisions. One is under the Schedule 16 of the 1951 Act, which says that if any area which is required to be kept vacant for the purpose of any sanction which has been obtained, and here a sanction has been obtained of the earlier plan, any area is kept vacant, then that area cannot subsequently be hived off and form the site for another sanction later. This is consistently there, my lord, in the statutes. In the 51 Act, Schedule 16, there is a provision. In the 1990 building rules, there is a provision. In the 2009 building rules, there is a provision. Question is, how did so we presented this as the first challenge, and then we said, insofar as the earlier plan is concerned regarding the macro premises, there were sanctioned car parking spaces on that 700 square meters of land. Corporation has used 3 affidavits. In each of the affidavits before different forums, it has said, yes, it was presented as a place for car parking spaces. To whom the title to the car parking spaces would lie, or whether we would have a right or title over the car parking spaces, would not be germane in my school submission for the purpose of the writ proceedings and the statutory authorities proceedings. What would be germane is whether that portion was presented for sanction of car parking spaces and sanctioned as such by the corporation. By that sanction, no one gets any right, title or interest, because it may be eminently possible that that portion may not be a common area or otherwise. But what happens is that gets subsumed in the earlier plan. The moment that plan is constructed, moment the building is constructed in terms of the plan and the construction attains a finality, all the areas which are present in the macro premises get bound, married, subsumed to the plan. There can be no question of hiving it off. And that is why, my lord, is the provision which we are relying on, that Schedule 16 provision. Please have a look, my lord, at that provision. It's an act, plan under the 51 Act. There's a provision in Rule 16 saying exactly, Schedule 16, exactly saying this.
KMC Act.
This is CM Act 1951. So I'll just hand over a copy. This is the earlier act. Schedule 16 Schedule 16 my lord, in page 12 of our can, we have set out, my lord, the provision of Rule 20 for your lordship's kind convenience. Only this much and nothing more in respect of this writ. So we say that portion has now been hived off.
Thank you. The original site.
700 square meter is kept reserved for ceiling purposes or something like that.
I'll come to that. Please be satisfied when I submit that it is not under dispute. Yes, I'll come to that also. Whether feeding of estoppel applies or not are all civil considerations. Need not trouble your lordships. Yes, just recapitulating.
Please
come to page 12. This is important. This is the only important part. The mutation writ failing, etc., does not cause us any trouble because mutation does not create or extinguish any right, title, or interest. There are civil suits pending. The title or interest or the lack of it will be adjudicated there. Here, Please see, my lord, 12.1.
Can one?
Yes, can 1, page 12, paragraph 12. Seventy. admit there is construction at the plinth level of this particular structure. When this new plan, when this new building comes up, it will come up straight in front of my face. Second, it will come up admittedly or indisputably at least in a portion which was shown to be part of the land kept vacant for ground coverage restrictions. So the original sanction now completely goes for a toss because a land dedicated to it, married to it, subsumed by it, gets free again for the purpose of becoming a site. Now, this is the primary reason why we had drawn the attention of the municipal authorities. And how are we affected? The answer is clear. No one denies the fact that the members of the association are actually interest holders in the various units of that commercial building. No one denies the fact that all the members of the association actually, or at least substantially, stay there or occupy the place for commercial purposes. The moment my residence or situs in that building is not denied, I don't have to show anything more on title for these considerations. It may so be that in the schedule of my deed that 700 square meters has been accepted. Let us say it's been accepted. Let it be accepted. I don't gain title over that 700 square meters as if it were an estate in fee simple in my hands. I may not even get common rights or interest in respect of the 700 square meters because that has been expressly accepted. Though questions of feeding the estoppel of grant after the grant will come in, but I'm not arguing all that here. All I'm saying is this: the moment you admit that my members reside in the building constructed in execution of the original plan qua the macro premises, that gives me sufficient locus to question the hiving off of that premises for the purpose of presentation as a new site. I need not be owner of a premise or of a unit. I need not be sublessee of a unit. I need just be in possession. Even a licensee, if I am, and if it's an association of licensees, can come forward and raise the claim. Because the claim is regarding violation of statutory law, of rules having the force of law, the infraction of which will automatically cause nuisance. I don't need to prove actionable nuisance like a normal claim in a perpetual injunction suit. The infraction of these rules will automatically create nuisance. And that is the reason, my lord, we had applied. Now kindly see what the learned single judge has said, my lord.
Why plea was not taken? Why this plea was not taken? Submission was not done.
Where, my lord?
At the time of argument.
My instruction, my lord, I was not there. I was there but not there. I was not there in the matter.
This argument was not made.
This argument was not there.
But then we don't even know whether this argument was advanced before the learned single judge.
It was, and kindly see how it was dealt.
Or the corporation.
Yes. Now, please, no. Corporation didn't have any occasion to deal with this. Corporation, act second, brother, please. Corporation did not have any occasion to deal with it. We had filed representations. They were sitting tight. Our petition was for a mandamus directing them to act. Kindly see what the learned single judge says in this context. Please come to page 73. And this is what shocks us really. Please see page 73 once. I'll not take your lordship into the facts because we all know the facts. Please come to the reasoning portion, internal page 4, running page 76. And this, according to me, my lord, in my reciprocal submission, is perversity and or illegality which your lordships will interfere with in letters patent appeal jurisdiction. Please come to the last sentence of page 76. From the submissions made on behalf of the parties, it appears that there is a dispute with regard to the ownership of the 700 square meters of land, vacant land. The petitioners have not been able to produce documents / title deed to show that the aforesaid 700 square meters were at all sold to the petitioners or were included in the schedule of the deed of conveyance of the petitioners. Agreed. Prima facie, it appears that the 700 square meters was separate and left out from the portion of the land sold to the petitioners. Agreed. Now, my lord, kindly see. The petitioners rely upon an affidavit affirmed by the Kolkata Municipal Corporation in an earlier writ petition in the year 2003 to show that the vacant portion was shown in the sanction plan pursuant to which construction was raised by the petitioners. So there are 3 affidavits of the corporation which say this. Now, my lord, kindly see the reasoning. This is where, my lord, I beg to join issue with great respect with the learned single judge. The court fails to appreciate as to how the portion which was never sold to a party could be shown as vacant land for permitting sanction for easing construction. The court fails to understand, kindly, I'm rereading it for your lordship's kind consideration. The court fails to appreciate as to how the portion which was never sold to a party, agreed, could be shown as vacant land for permitting sanction for raising construction thereon. With great respect to the learned single judge, I don't see the connection. If that land which services the ground coverage requirement of the rule has not been sold to anyone, it can't be shown as a vacant land available for part of the site for sanction.
If you apply for sanction and there's a piece of land contiguous to your property.
It's part. Contiguous is later. It's after the mutation and separation that it becomes allegedly contiguous. It's part of my property. That land was part of my property. Please, my lord, kindly do. This is the indisputable part.
Is that
227? Yes. We've got our inspection book, corporations register, all of that say that the total land area in 227 is 2 bighas and something odd, including 700.
কবে বলছি 9, 10, 11, 11
So, my lord,
করে ফেলার প্রতিষ্ঠাটা চ্যাপ্টার কম থাকে।
Just 2 things. The orders record by that this writ petition appeal was heard along with the other. Several orders record. All these points have been
my lords are hearing the appeal for all its worth. Lord, let me place the points.
Point is how long?
The only difficulty is, my lord, this full court thing and this 330 thing is really causing us to bleed now. If I had slight more hearing at the bar or slight higher standing at the bar, I would have gotten this thing banned.
First week you are here.
I'm not here on the up to first 3 days. I'm not there. That's all.
We were thinking of having it on the Wednesday.
If it could be on Thursday,
Thursday, my brother cannot come.
Friday or
Friday.
13th.
Friday, 3 o'clock.
We'll also keep it at 2:30. I'm sorry.
No, Mr. Banerjee.
Fair,
And this
This time, my lord, is serious. I am also serious. I've not beaten around the bush at all. I've not beaten around the bush at all. This is the point.
Beating around the bush or to the point, you will have to conclude.
Finish by 3:30.
And as we said, file your written notes. No problem.
In the meantime, we'll get our written notes in order.
Then we'll have to give them an opportunity.
Yes, of course.
Not more than 5 minutes, hopefully, with whatever he has said so far. All covered by.
Oh, lekho.
I will just show a paragraph of my.
And I can show, my lord, that this particular
Mr.
thing was not.
Banerjee, from a learned senior advocate representing the appellants, makes argument in MAT 617 of
2023.
2023. Stop. He does not conclude. Paragraph lists the matter once again, comma, along with the 2 review applications, comma, on June 13, 2025, comma, marked 3 p.m.
Obliged, your lordship, deeply obliged.
আমি জানি না আর অ্যাপিলের সাইডে তার অরিজিনাল সাইডটা করেছিল সেটা
Original side matter, new moves on item number 1.
Well, this matter is the partition suit of Kundu Chaudhury's. Several properties were directed to be sold by your lordship from time to time. The first order passed by your lordship in this matter.
You are appearing for Mr. Sinha?
All the parties are appearing, my lord, here before your lordship. The parties have sold their properties in terms of your lordship's order. Your lordship's order was modified.
For the state, not lordship will hear me, not. I appear for the state. That we have got ourselves added, not as a party to the suit, not. I need to tell your lordship what's going on in this matter.
I do not know what is going on here, but your lordship was pleased to pass diverse orders in this matter. The first order passed by your lordship is on 22nd July 2015 at page 37. At page 37, lordship directed to sell the properties in terms of prayer A to G.
Would you like to use any affidavit?
I'd like to use it. My lord, what's happening, lord, is suit of 1935, not disposed of. According to the preliminary decree passed, entirety of the land has vested in the state of West
So
Bengal.
this point was raised before your lordship did not entertain that. Even then, your lordship was pleased to pass order
Lord, thereafter, lord,
directing for sale of the
there's
property.
no contesting party. The parties that have themselves appointed.
Nobody ever contested. That I remember.
Joint receivers appointed, party receivers, not all properties are being sold. At least not there are 100 GS pending. 10 parties have applied not for cancellation of the sale, not conducted pursuant to orders of court.
But if all the parties agree to sell their properties, how would the state can come into
No,
the
they can't agree to sell vested land.
No, it's that point
Or
was
third-party
raised
land,
and that
or
point
the
was
lands belonging to third
rejected.
parties.
So that point was rejected.
Very well, Mr. Mitra, let the state bring on record whatever they have to say. This application has been taken out. On behalf of the different numbers 2 bracketed choto a, upper bracketed choto II, and 14 bracketed choto c, upper bracketed choto I. Praying for
Modification.
the following orders. Page 34 থেকে আর 35 থেকে A আর B. Set out করে দাও. Paragraph, Mr. Sinha, a learned advocate appearing for the state, says that state has been added as a party to the suit. Stop. The parties to the suit have practiced fraud by agreeing to sell vested land and oblique or land belonging to third parties. Stop. The state wishes to file an affidavit. Stop. Paragraph. Let affidavit in opposition.
Disputing this subject.
As তার আগে লিখে দাও একটা প্যারাগ্রাফে a state wishes to file affidavit. তারপরে next, Mr. Dotto, learned senior advocate appearing for the petitioners, strongly disputes the allegations made by the state. Paragraph, let affidavits be exchanged. Stop. Let affidavit in opposition be filed within 1 week after 2 weeks after the summer vacation. Date ta diye dao bracketed June 23. Bracket close. Stop. Reply thereto, if any, be filed within
2 weeks thereafter.
2 weeks thereafter. Abar date ta diye dao July 7.
My lord remembers the date also.
Huh?
Also remembers the date 2 weeks.
Simple arithmetic.
After 15th of July, not that week, not of 7th to 14th, I may not be not.
No, it's all right. Reply by July 7.
Any date after 15th.
Yes. Paragraph lists the matter on July 17. List the matter after July 15, 2025, whenever this bench is again available. Next, Daku.
Reassigned matter, item number 2.
My application, my lord. In this matter, my lord, the department has not accepted my vokalatnama because who has filed the vokalatnama, they have not disclosed it. Leave may be granted to file my vokalatnama my lord, in the department, my lord. And my lord, this application was assigned by before your lordship, my lord, at per request of the plaintiff, my lord. My lord, plaintiff have filed.
There was a decree by compromise.
Yes.
Now, my lord, an application was filed for recalling of that decree in the process while the decree was being settled. Now, my lord, your lordship passed an order on 16th of June 2016, whereby, my lord, your lordships recorded the submission of Mr. Surajit Nath Mitra, who was then appearing for the defendant. If your lordship kindly looks at that order of 16 June, Lord, he had made a submission that
16 June.
16
No, my
June
lord, this application was filed challenging the order dated 8 September 2015, my lord.
That order was passed by your
Is
lordship.
it a part of this application?
I'll give your lordship. It should be part of the file.
Whose application is this?
Defendant's application.
His application.
For recalling of the decree. Now, Lord, what happened is
Decree passed by me.
Decree was passed by your lordship, but in the interlocutory court when the terms of settlement was filed, and on the basis of the terms of settlement, the decree was passed.
Just a show mention has passed a decree. We
That
can
is the first decree.
Achha.
That was a part decree.
Okay.
Then, Lord, the property was kept out at that stage. Thereafter, the parties entered into a settlement, filed the terms, signed the terms, filed the terms, and based on which your lordship passed the decree. That order is dated 8 September 2015.
Yes.
Now, Lord, subsequently, sometimes in 2016, Lord, after the limitation has set in, Lord, this application for recalling of the decree was filed. And your lordship passed an order.
God, 1 second. It appears, at least from my order dated 8 September,
Yes, sir.
initially the parties settled the disputes accepting
The property.
the property is 77F Karaya Road.
Yes.
Therefore, Justice Sen passed a part decree.
Yes.
Then on 8th September, the parties said that we have settled regarding...
Terms of settlement was filed before your
Yes.
lordship. And signed, on the basis of the signed terms of settlement, your lordship passed the second degree, final decree.
Now, on what ground are they seeking recall?
Ground is that, Lord, it's very peculiar ground, but Lord...
Would you wish to file an affidavit?
No, Lord, we have already used that affidavit.
No, not in, no.
Yes, we have
In
used
this
it.
application?
Yes.
No.
There is nothing on record.
No, nothing on record, no copy was, sir. My
But
lordship.
I'm more concerned about what happened after this undertaking was given before your lordship on 16th of June 2016. Lord, there was an undertaking given that they will not deal with the property.
We don't have it here.
I'll give you. This is not the order of 16th. Please turn the page. The second last paragraph.
Oh, this is a GA of 2016.
Yes,
my lord, 2016.
And Lord, what happened was, post this undertaking, he has declared himself as the sole owner of the property and he has sold the property to a third party. Lord, we had to move an application to obtain an order of injunction restraining him from giving possession to that third party. Lord, there are documents on record which we have disclosed in our affidavit saying that, Lord, he has found an affidavit that he is the sole heir of Dijendranath Das. And he has executed a conveyance as the owner of the entire property.
So this is a change brief, Mr. Mondol?
Yes, madam.
Right.
So
through another set of advocates, an undertaking is given or a statement is made that they will not deal with the property. Then they change the set of advocates and now come before me after having sold the property. Affidavit's direction was given.
Yes, and we have affirmed an affidavit. But if the affidavit is not in the file, grant us liberty to reconstruct the brief, and we will file Lord the affidavit on record. But,
Is there any evidence that you actually filed your advocate on record? Docket number or folio number, something?
Evidence আছে that you have filed. Reaffirm করে file করে দাও না ভাই।
এটা তো evidence কিছু থাকবে, docket number.
But we'll get it reaffirmed and filed.
Reaffirmed and file it, yes.
If I may kindly be permitted, Lordship.
Who are you?
Lordship, I am the person who the sole defendant, the defendant in the suit has sold the property to me, Lordship. In the suit, Lordship, I have filed a general application, a GA application for intervening. That is pending, Lordship, because of the pendency of this particular application, Lordship. So in my,
That is not assigned to me.
No, Malad, that was assigned.
that is partner Justice Mojumdar, Lordship. She was the
So this should go before his lordship.
Lord, because Lord, it's a consent degree under Order 23. That is the reason perhaps the matter has been assigned before your Lordship.
Yes, Malad.
Because Lord, it was a consent degree under Order 23.
Yes, but there may be a conflict of decision.
What we'll do is, once your Lordship gives direction here, we will ask for assignment of those matters also. Because I have obtained.
Why don't you take this away from me? Much better for me.
Your Lordship.
Me, I don't have the time to sit single, Mr. Kaur. So do whatever you, please try to relieve me of this. Otherwise, I can't promise you when I'll sit again.
What I suggest is that kindly release the matter on the ground that your Lordship can't
Yes.
sit singly and
Yes,
this
yes, yes.
so that we can Lord ask.
Yes. This is an assigned matter, stop. However, comma, in view of my present determination on a division bench, comma, it will be very difficult for me to hear out this matter. Paragraph, let this matter stand released from my list and be placed before the Honorable the Chief Justice for appropriate direction.
Leave me granted to file the Vokalatnama, my lord.
কেন আমি লিভ দেবো কেন নেবে না কেন না Thank you. We understand, I understand your joint request to the judges to rise at 3:30.
Kindly item number 9, first time, direct have the copy of the contempt petition of the contempt.
দাও আপনার এটা কোথায় কে আছে any matter which is listed for the first time?
Item number 9, man. Item number 9, man.
Only those two, only those matters. তিন নম্বরটা ডাকো
Appellate matters, item number 3.
দাও
And this is the order dated 3rd February 29, page 29. Yes. তুমি তোলো এটা লাগবে আমি তুলবো
নম্বরে 12টা আমি হচ্ছে ওই ইয়াদ করতে হবে না
পরেরটা বার করে রাখো নয় না কত বলছে
না না
order dated
Your Lordship's past order was 3rd of February, my lord, 2017, my lord. And communication page 17.
issue. This contempt application has been taken out alleging willful violation.
One thing, a new incumbent be added, my lord, as a party, my lord.
তার প্রথমে leave is granted to learned advocate on record for the petitioner to add the new incumbent
Murari Mohan Mondal
in the post of District Inspector of Schools, bracket SE, bracket close, comma, Uttar Dinajpur, as respondent number 2 in the contempt petition. Stop. Let necessary amendment be carried out to the cause title of the petition. Stop. Paragraph. This contempt application has been taken out alleging willful violation of a judgment and order dated February 3, 2017, whereby WP number 2465, bracketed W of 2017 was disposed of. Stop. Now, disposed of by directing the District Inspector of Schools, bracket SE, bracket closed, comma, Uttar Dinajpur, comma, to approve the appointment of the petitioner as clerk within inverted comma or capital C debe in the vacant post of the Asharubosti Jalaluddin High Madrasa. এই page 22 তে অর্ডারটা আছে দেখেন Madrasa within a period of 3 months from the date of the order. Stop. Paragraph, learned advocate for the petitioner says that in spite of, where did you communicate?
Page 17, my lord. Kindly see.
In spite of due communication of the said order, comma, alleged contemptors have taken no steps. Stop. Paragraph. Let copies of the contempt petition be served on the. You serve on both the contemptors.
Yes, lord.
On the alleged contemptors, and affidavit of service be filed in court on the next date. Paragraph. List the matter after the summer vacation when this bench is again available.
My lord, 7 and 8 are same, my lord. Same district, same DI, my lord.
7 and 8. First
7 and
time.
Same, my lord. First time. my
Order
lord.
dated.
My lord, order dated, my lord.
তাহলে দাও ওরকম ভাবে হয় না 7টা দাও 7টা দাও
Item number 7. 7 এর নাম্বার হচ্ছে 699 699
WPA নম্বর
same type of matter no Uma Devi
only date different, my lord. Same district, same.
তাহলে
But added
ওই তো
respondent, my lord. DI.
date of the order is
Yes, my lord, 28th June.
June 28
2017, my lord.
2017 হ্যাঁ এখানে কিন্তু পিটিশনার্স হবে ঠিক আছে পিটিশনার্স আর কিছু পাল্টাবে কি একই আছে সেম আছে হ্যাঁ তাহলে এখানে কিন্তু তুমি কন্টেম্পটার দুজন ছিল here also that leave to
Yes, leave, new incumbent Murari Mohan
leave টা
Mandal.
দিয়ে দেবে কিন্তু এখানে রেসপন্ড দুটো ছিল বলে as respondent number 3 আর তো কিছু না সব সেম then
And in respect of other matter, item number 8, my lord.
yes
Date of
order
22nd September
2017 huh? How many petitioners there?
My lord, here petitioners, my lord, 3 petitioners.
How many respondents?
My lord, 2 contemners.
Two তার মানে এখানে number
DIP added as a respondent, my lord.
so,
Murari Mohan Mandal, my lord.
as number 3 you will add
Yes, my number.
all right হয়ে গেছে
Much obliged.
Item number 10.
Number 9.
9
Item number
9 দাও
Item number 9.
Order dated 9th October 2018, my case 28. 9th October 2018.
representation
Leave is granted. Leave is granted to add the new incumbent to the party.
new incumbent leave is granted to add the new incumbent in the post of district inspector schools bracket AC bracket North 24 Parganas as respondent number 2 in the content petition the related appropriate amendment be carried stop paragraph this contempt application has been taken out no order has been passed on the representation no hearing granted কি বললাম this contempt application has been taken out alleging willful violation of a judgment and order dated October 9, 2018, whereby WP 19506 bracket W of 2018 was disposed of. Stop. The operative portion of the order reads as follows. Page 29 থেকে bracketed portion. Paragraph. Learned advocate for the petitioner says that in spite of due communication of the order, no step has been taken by the parish contemptors in terms of the order. Stop. Paragraph. Let copies of the contempt petition be served on the alleged contemptors and affidavit of service be filed in court on the next date. Paragraph. List the matter. Immediate after the
Item 10,
Item 12, my lord.
12.
Why are you doing like this, sir? He's saying 10. Wait.
10, my lord. Contempt application, a lordship's order is page 20.
First time.
First time. What happened, my lord?
Now nothing has happened. Just give me the file.
Order dated February 2021.
এই চুটে 10 নম্বরটা
February 2021, page 20. The Lordship was free to direct the authority to disburse the my lord amount. After that, my lord, they have filed an application for modification in this contempt application.
yes
And my lord, thereafter, my lord, another petition filed before this honorable court by the same petitioner. And my lord justice, my lord, Aniruddha Rai directed to deposit the amount.
কি ঝামেলা this is a contempt application first time
Yes, first time.
serve
No, I am not served. Not served, my lord. But despite of that, my lord, they have filed an application.
what is the date of the order
5th February 2021.
your client's name is Sikimuddin Sheikh এই দেখো this contempt application has been taken out alleging willful violation of a judgment and order
Page 19.
dated February 5, 2021, whereby WPA 8932 of 2020 was disposed of by directing the Farakka barrage authorities to disburse the applicable compensation in favor of the petitioners on an early date and in any event within 8 weeks from the date of the order. Stop. Paragraph learned advocate for the petitioners says that in spite of due communication of the order, comma, no disbursement has been made.
And on the other hand, they have filed an application for modification.
That is not before me, sir. Stop. Paragraph let copies of the contempt petition be served on the alleged contempt laws and affidavit of service be filed in court on the next date. But I release the matter, just same ache. Yes, Mr.
12. My lord, item number 12 was issued, but contemptor has been changed. So new incumbent be added. And
Leave be granted, leave is granted.
And
New incumbent in the post of
post of my lord, district inspector of school AC Murshidabad.
District Institute Schools,
Suniti
bracket
Sanfui.
AC, Murshidabad.
Suniti Sanfui.
তারপরে ওই appropriate amendment, হ্যাঁ? আচ্ছা।
Order dated 29 December 2014. Humadev. So my lord, was issued.
Rule was issued.
Earlier contemptor.
Acha.
But now my lord, new incumbent.
Then you have to serve on him first.
Yes, that's why I am praying for the new incumbent.
Paragraph let a copy of the contempt petition be served on the added respondent and affidavit of service be filed in court on the next date.
Other side is paid.
You will represent him?
Yes, yes.
So
So comply the order. Add my, I want to add.
খালি ওই leave grant করে দাও ওটা করুক।
And in the meantime to comply the order.
Paragraph lists the matter
2014
once again with your after summer vacation. Stop. On that date, either the alleged contemptor shall file a compliance report or shall explain why the order in question has still not been
2014 order.
complied with.
Milan Kumar, yeah. Milan Kumar, advocate for this case.
দিন কপিটা দিন বলো লিখে দিই
आप कब तो ये लिखने के हाथ देवो टाइपे ना देवो এখন
ওর হাত কপে ও পারবে আমাকে দিন আমি লিখে দিই আমাকে দেন না লিখে দিচ্ছি
অর্ডার হয়েছে
এই আমি এটা লিখে দিচ্ছি
3 7 9 10 12 তাই তো এখন দেয়া যাবে না এখন বদলে দেয়া একটু দিন না
নিন দাদা এটা নিন 12
মেলা বলছি 8 আছে মেলা মেলা 3
সাত আট
অ্যাড না করলে হবে না।
হ্যাঁ, আট দিয়ে দিয়ে দেবো।
অ্যাপিয়ারেন্স দিয়েছি, অ্যাপিয়ারেন্স দিয়েছি।
সাত আট নয় 10 12
সাত আট সেম হলো।
সব কটাই সেম অর্ডার।
অর্ডার হয়ে গেল।
7 8 9 10 এখানে লিস্ট হয়ে
অর্ডার